Please rise. Justice of the Appellate Division, Supreme Court First Department. Hear ye, all persons have been admitted to the Appellate Division. Draw near, give your attendance, and you shall be heard.
Good afternoon, and welcome to the Appellate Division First Department. I will go through the calendar and then proceed on to arguments. You all know the drill. Please ask for the time that you need, not the time that you want. We have 6 hours of requested argument time, and I don't think anyone wants to be here till 8 p.m. Okay, People versus Krishawn Graves. 6 and 2? Okay. Okay, 6 and 2 and 6. Gar Silpy PC versus Weir or Wire. Okay, we have no appellant. Do you wish to still argue? Okay. All right, so submit in 2 minutes. J. Neal versus Maria M. is submitted. Kearns versus Ashita. Submitted. 46th Street leaseholder versus Hercules Corp. I'm sorry? 4, 6 and 2 and 4. People versus Michael Kraus. Submitted. Tinty versus PMG 23-10. Okay. 5 and 2 and 5. United Synagogue versus Superintendent. Okay, you have no respondent. How much? Oh, okay. All right, 5 and 2 and 5. I know, and I gave you 5. People versus Maria Rodriguez. Okay. 5 and 1 and 5. Ciro versus Alexi. Submitted. People versus Phyllis Tate. 6 and 2. 6 and 2 and 6. Dragonetti Brothers versus Verizon New York. Okay. 5 and 2 and 5. Schnur versus Bellestri. Okay. Okay, let's do 6 and 2 and 4 and 4. People versus Henry Benedict is submitted. Hoffman versus Tolbill. Okay. 5 and 2 and 5. People versus Tony Santiago. Submitted. Pappas versus B&G Holding. 6 and 2. Okay. 6 and 1 and 5. First New York versus New York State Division of Housing. Okay. Okay. All right, 6, 1, 4, and 3. And People versus Devin Keat is submitted, and BDO USA versus Franz is submitted. First case on the calendar, People versus Krishawn Graves. Give me 1 second while I... Can I get help with the clock? It's not, it's going backwards. See how it's not? It doesn't seem to be. All right. Okay. My apologies, usually, okay. Now, sorry, you may proceed.
Thank you. Good afternoon. Ronald Zapata with Legal Aid for Appellant Krishan Graves. Here, the prosecution failed to meet their burden to establish the legality of appellant's arrest at the suppression hearing when they presented only unsubstantiated hearsay evidence of the supposed warrant for appellant's arrest. Prosecution was required to
You
present.
didn't raise that issue below, did you?
I'm sorry?
You didn't raise that issue below, did you?
It was raised below in both the omnibus motion and the suppression motion. In the omnibus
The failure
motion.
to establish the reliability of the warrants?
Yes, Your Honor. Well, the motions both stated that there was no warrant for the arrest. The omnibus motion said there's no basis for the search and arrest, and that appellant
But what
was.
directed the court's attention to the issue that you're now raising on appeal about the warrants? There's nothing in the omnibus motion that directs attention to that.
With all due respect, I disagree with that, because if both motions stated that there was no warrant for the arrest and that there was no reliable information or basis of knowledge for the transmitted information for the basis for the arrest, and the basis of arrest was a warrant, then that is sufficient to raise that issue before the court. Both motions stated expressly that he was arrested without a warrant.
And that's the issue that you argued at the suppression hearing.
It was not argued at the suppression hearing, but it didn't have to be. It was preserved by the motion itself. And even after the omnibus motion, after the prosecution stated conclusively he was arrested based on an arrest warrant. And even then, appellant argued in his suppression motion, no, there was no warrant for his arrest, and therefore it was preserved in this case. And therefore, because it was preserved, the prosecution had a burden at the hearing to present evidence that the warrant was reliable and that it was valid, and didn't present any such evidence. And therefore, without presenting any such evidence about the warrant, they failed to meet their burden to establish that the arrest was valid. Unless there are any questions about that, I'll move on to the prosecution's new argument on appeal now, which is that the arrest was based on a request for the MetroCard, which is completely contrary to what the record states. The testifying officer explicitly stated that the arrest was based on the warrant, and that he only stopped the appellant because of the MetroCard swipe request. He stated that when he was expressly asked on page 8 of the hearing transcript why he arrested the appellant. He said because he has outstanding warrants. And again, on pages 21 and 22 of the transcript, he said that he arrested the appellant only after finding out he had outstanding warrants. And therefore, the court expressly stated in its ruling that the arrest was based on the outstanding warrants and not on the MetroCard request, a swipe request. And therefore, because the arrest was based on the warrants and not on the MetroCard swipe, the search would only be valid if the prosecution met their burden regarding the arrest based on the warrants, and they did not do so here. So under Reed, Simmons, and Mangum, by this court, the search was invalid and was not a valid search incident to arrest. Unless there are any.
Do you wish to be heard on the issue regarding the grand jury presentation in this case?
Yes, Your Honor. So the prosecution committed a jurisdictional error by failing to inform appellant that a first grand jury had taken no affirmative action and that they were
Now, what does that mean?
No affirmative action?
Yeah.
Yeah,
I've never heard that in criminal practice. A grand jury was convened, evidence was taken, presumably that grand jury was charged and was submitted with the case to decide one way or the other whether a true bill should be voted.
Yes, Your Honor.
How did we result in no further action?
That's a great question, and the problem with me is I'm handicapped because I was not provided the grand jury minutes, so I don't know exactly what the grand jury stated. But the prosecution in their brief here has now conceded that the first grand jury's action should be considered a dismissal, and therefore whatever language is used for affirmative action or whatnot, they agree that it should be considered a dismissal. And
So, wait. So does that mean that the grand jury returned no true bill and dismissed the case outright? Or that they returned no true bill and intended for the prosecution to prosecute this case as a misdemeanor?
Well, I don't believe it's the second. Whatever the language was used by the grand jury, which I don't know what it is, but since the prosecution is conceding
So
it's
when you say dismissal, what does that mean?
a dismissal means that there's a higher standard for what the prosecution must
What
present.
does it mean to you that the grand jury did when you say there was a dismissal?
I'm sorry, excuse me, King.
When you say there was a dismissal, to you, what does it mean that the grand jury did?
It means that there's, again, I'm in the dark here because I don't know exactly what happened in the
Yeah,
grand
but
jury
when you
minutes.
use that term, what did that mean to you?
What it appears to here is I would think that the prosecution did not give them sufficient time or did not instruct them sufficiently to decide whether to grant a bill or not, and therefore it has to be considered a dismissal under Court of Appeals precedent.
So when you say that, are you saying that it means the grand jury at the end just took no action?
It's tough for me to
One way or the other?
state it. It's tough for me to state because I don't have grand jury minutes, but because it's considered a dismissal, what's important here is then how you consider the resubmission application to the second grand jury, and there's a much higher standard for that. The Court of Appeals in People v. Cradle said that when the first grand jury issue is considered dismissal, and resubmission should be granted sparingly and discriminately. And in the Court of Appeals case in Wilkins, the court stated that the prosecution should avoid gaming the system to, for instance, find a grand jury that's more receptive to their arguments. And here, the prosecution, they made a strategic decision not to present the evidence, the supposed new evidence that they had for the second grand jury. They stated in their resubmission application that they had supposed new evidence of bank records. But also in that application, they essentially admitted that they could have gotten that evidence through due diligence, but decided not to. And that was their strategic decision.
Okay.
And-
I'll hear you on rebuttal.
Thank you.
Okay. You may proceed.
May it please the court, Molly Morgan on behalf of respondent. People's ex parte application to represent charges to a second grand jury was consistent with defendant's statutory rights.
Was what?
I apologize. It was consistent with
You
defendant's.
can lower your, so that we can hear you if you wish.
I apologize, Your Honor.
It's okay.
It was consistent with his right to testify before the grand jury and his rights to due process and counsel. First, I would.
But I want to understand what happened. The first grand jury received 3 witnesses. They were charged fully. What happened?
Well, Your Honor, with regards to their vote, or anything that, anything that occurred during the charge and beyond, I don't think I can answer that question.
Why not?
Because
I can't decide this case without knowing what happened on that vote. And we requested, this court granted a request for the grand jury minutes to be provided to this court, and conspicuously absent is what jury action was taken on the first vote. So these records are incomplete as far as I am concerned.
well, I apologize. I believe those are the full minutes. There was no kind of.
No
omission on
jury
our part.
action was taken. What does that mean? See, the grand jury has very limited options. They either vote a true bill they dismiss the case, or they let it proceed as a misdemeanor. What other options are there? I practiced criminal law, so explain to me what happened here.
We don't know, and the minutes don't reveal that, and
That there is a record of everything that transpires in front of the grand jury. So after the jury was charged, whatever vote was actually handed down by that grand jury had to be recorded. This court wants a copy of that conclusion. I'm hereby requiring you to provide that after this argument.
the office will provide those expeditiously if we have them, Your Honor.
Or an explanation why you don't have them. There is an answer to my question. And this case can't be decided until I have that answer.
Well, Your Honor, all I can say is we know it wasn't a no true bill,
How do we know that?
because otherwise the prosecutor wouldn't have sought to bring the same charges to a
How
second.
do I know that? Where is that recorded anywhere that this court can verify?
Again,
I have two grand jury transcripts. The first one, the grand jury is completely charged. And then the transcript is silent as to what they did with that vote. Next, I have a second grand jury, which has much of the same evidence. And frankly, the additional evidence wasn't necessary to get an indictment on this case. So I'm not convinced, based on what I have before me, that this procedure was proper.
Your Honor, it was completely proper in lines with CPL 190-55A and in line with 190-75-3. When there's not a no true bill, a lower standard applies. There was no true bill here. The people had two good reasons to submit to a second grand jury. The first being that there was no affirmative action. There was no true bill. The second being the new records, and the trial court providently granted.
So you agree that had the first grand jury voted a no true bill, that's the end of the case?
Not necessarily, Your Honor. If there were a no true bill, the people could have,
If the first grand jury voted not to indict,
yes.
are you permitted to represent it?
Yes, if the people bring good reasons to present, and those good reasons.
So you can re-represent until you get an indictment? Is that the idea? I've never heard of such a thing.
Well, CPL 190-75-3 provides that a prosecutor can seek to represent one time after a no true bill in cases such as where there's new additional evidence to present. That doesn't have to satisfy a newly discovered evidence standard. So here the people, when they brought their application to resubmit, the bank records were new evidence. Again, it didn't have to be newly discovered evidence. And that was sufficient to warrant even representation under 190-75-3. But again, we don't concede that the first grand jury's no affirmative action was a no true bill. It's something distinct that happened.
You had one grand juror who was very, very disturbed by this case and was very vocal about it. So I find it really disturbing that that particular grand jury would have not reached a result one way or the other, which is why I want verification of that.
Again, if those records are in our possession, I will provide those records.
Again, just to review, so it's your position that even if the first grand jury voted a no true bill, what were your options?
Our options were a little bit more limited, but we could seek to represent the charges pursuant to 190-75-3, if I might just finish.
Yes.
With additional evidence, which again, the bank records satisfy that. But in that case, we're limited to one request to resubmit.
Was the guilty plea here, did the guilty plea here occur after the second resubmit?
Yes, Your Honor.
And defendant was not advised that the grand jury, the first grand jury took no action and that the people were representing again?
Defendant learned of the second representation at some point.
After he was indicted by that grand jury.
That's correct.
So he was not afforded an opportunity to perhaps change his mind about going into the second grand jury, since the first one apparently wasn't satisfied with the evidence.
Well, Your Honor, he certainly had noticed that the case was proceeding to a grand jury. Again, at arraignment, we provided that notice.
At the first arraignment,
At his criminal court arraignment, yes.
right.
He
I'm
was-
talking about the second, I'm sorry.
At the second arraignment,
At the second presentation, he was not made aware prior to that second presentation that the DA's office first presentation resulted in no jury action. He was not aware of that, correct?
No, and he wasn't entitled to be aware of that fact because he said he didn't want to testify before the first grand jury. Defendants have a circumscribed right to appear as a witness and testify. They don't have a right to know when exactly a case is going to the grand jury unless they say, I would like to appear as a witness and testify.
So the people have a right, if they find new evidence, even after the first grand jury has taken no action, they have a right to go back in, but the defendant doesn't have a right to decide whether perhaps maybe I should testify, since the first grand jury wasn't so convinced with this evidence. You don't think that that changes the dynamics, and that a defendant, in order to preserve their due process rights, should have been notified?
It may well change his strategy, but that doesn't mean he's statutorily entitled to that notice. He said he didn't want to testify. He doesn't have a right to know what evidence is going to the grand jury or what the grand jury thought about it. He just gets the right to appear and testify, and that's it. And he has to serve written cross notice of his intent to do so. When he fails to do so, the plain language of the statute doesn't require the district attorney to notify him of the grand jury presentation.
At arraignment, he has to declare whether or not he wants to testify.
Yes, that's usually when it happens.
And here he did, and then either through counsel's advice or change of heart, he withdrew that, correct?
That's correct.
Okay.
So, and once he withdraws that grand jury notice, the statute doesn't require the people to give further notice of the fact that something's happening at the grand jury, whether with this grand jury or a different grand jury. He just gets that one time, under the statute, he gets that one-time notice. He's got to declare whether or not he wants to testify. If he withdraws that desire to testify, that's the end of his right to testify. Unless perhaps if he does something affirmative and says, you know, if I've got some evidence to present to the grand jury or something like that. But other than that, there isn't an obligation on the people to notify him again, oh, this is going back to the grand jury.
That's exactly right, Your Honor. He has that limited right, and he very may well have decided to change his mind and submit that written cross notice and say, I would like to appear and testify. There were 6 months between his criminal court arraignment and the indictment. At any point, he could have reversed course and submitted a notice. But again,
But how does he submit a notice to a second grand jury presentation he doesn't know about? See, that makes no sense. Right? I agree with you. If he knew that that the DA's office was still considering representing, right, then I agree with you. If he slept on his obligation to notify you, you know what, if you're going in a second time, I want to testify, I would agree with you 100%. But you're asking the defendant to be clairvoyant because you didn't tell them you were representing. So how could he serve notice of something he didn't know about?
During that, you waiting for an answer?
Go ahead.
During
No,
that-
I don't think there is one, but go ahead.
During that 6-month period, there's nothing which would have stopped defendant's attorney from notifying the district attorney's office, if you're going back to the grand jury, my client wants to testify.
that's exactly right. And he could have even withdrawn his first grand jury notice and said, if this case is represented to a second grand jury, I would like to appear. And the office would have had to honor that. Again, there's no indication in the record that his withdrawal was conditional or other limited in any way. He withdrew that notice of his intent to testify, and that's it. The grand jury is...
Because once you get notice that he wants to testify, if the grand jury has not yet voted a true bill, you lose that indictment. That indictment's going to be dismissed. If he notifies you that he wants to testify and you don't honor that, that indictment has to be dismissed.
Yes, provided it is a true failure to facilitate his right to testify, then yes.
How often are cases presented to multiple grand juries before there is an indictment?
I truthfully can't speak to
That's
that.
very rare, isn't it?
I imagine it is quite
It
rare.
is usually presented only to one grand jury. So a defendant would not be expecting that the case would be presented to a second grand jury if there's no action taken by the first.
Perhaps, but again, he could have when he withdrew his notice of intent to testify, he could have limited his withdrawal in that way and said if there is a second grand jury presentation, I would like to testify. And again, there were 6 months between his criminal court arraignment.
Counsel, to me, that doesn't help you. To me, what that says is the defense believed they were fighting a misdemeanor case at this point. Because if a grand jury doesn't vote a true bill, then the only thing left would be misdemeanor charges that you could proceed on. So I truly don't understand how this all happened, but we've heard your argument. Thank you so much.
She's supposed to respond.
Thank you.
To remind her.
Huh?
She's supposed to give.
Yes, and please don't forget to send me whatever statement is available that tells me what the grand jury vote on the first grand jury was.
Yes, if we have anything, I'll send it. Thank you.
Okay. You may proceed.
To get my glasses on. Just quickly, one, if the grand jury minutes indicating whatever the grand jury vote was aren't provided, obviously there must be an adverse inference made by the court on that. And I just wanted to point out, so regarding the plain language of CPL 19055A, there's absolutely nothing in the language that says that the prosecutor only has to provide notice for a first grand jury proceeding. It specifically says a grand jury proceeding. And so if a first grand jury doesn't do something, then, and it's presented to the second grand jury under the plain language of that statute, the prosecutor must notify the defendant of that second grand jury proceeding as
If you
well.
give notice at arraignment that you want to testify at the grand jury, and then you withdraw that notice, so there's a continuing obligation on the prosecutor to notify you of something?
Yes, if something goes to another grand jury, a grand jury, then under the statute, there's a notice requirement, especially in that kind of situation where a defendant can look at the,
So you say which section provides for that?
19055A. It always talks about a grand jury proceeding. The prosecution wants to replace the word a with first, and that's just not correct. And if you were going to do that with statutory interpretation, then defendant has a right to testify at a trial. Does that mean they can't testify at a second trial or retrial? Absolutely not. And so under normal statutory interpretation, that just makes no sense in what they're saying.
Counsel, let me just ask you, is your response the same if the reason there was no action in the first grand jury was just because the grand jury ran out of time? Would you take that position? Are you taking that position if that was why there was no action taken?
Well,
So in other words, 30 days or whatever ran out, and then I present the prosecution presented to a second grand jury. You're saying even in that circumstance, the prosecution had an obligation to tell the defendant?
Yes, Your Honor. Because under the statute, it's about a grand jury. So if another grand jury is going to look at it, the defendant has the right to consider that in their decision on whether to testify or not. If they see a first grand jury struggling with a decision.
No, and I'm not talking about struggling. I'm talking about the time ran out.
Yes. Well,
You're saying if the time ran out and it was presented to the next grand jury or a new grand jury, that the prosecution would have to ask the defendant again under those circumstances whether he wanted to testify?
yes, Your Honor. Well, the problem with that is the CPL allows the prosecutor to extend the time for, even when the time runs out for the grand jury, to extend that time for them to consider it.
No,
And so
I mean,
they're under
I'm
that
not saying
obligation to
that.
do
I'm
that.
just saying, assume, you're saying that that's a hard and fast rule regardless of why there was no action. That's all I think I'm asking
Yes,
is.
yeah. Under the
Okay.
statute, if it's presented to a different grand jury, then there must be notice.
Okay.
Thank you.
Thank you.
Okay, Silby versus Panther Wire. You have 2 minutes, sir.
Yes. Good afternoon. If it may please the court, Carl Scheuerman from Warner and Scheuerman for the plaintiff respondent. I just want to make one brief point on the arbitration issue. The defendant appellant argues in a reply brief that she can relitigate the issue of her alleged right to arbitration because the doctrinal law of the case doesn't apply to denial of a motion to dismiss. But the defendant didn't just move to dismiss and had that motion denied. They moved to dismiss and to compel arbitration specifically. And the court below denied the motion to compel arbitration. And then they try to relitigate it on the motions for summary judgment. But a denial of the motion to dismiss and compel arbitration is entitled to, doctrinal law of the case does apply to the extent she requested arbitration. I just want to make sure that was clear here because the briefs were not very clear. And unless the court has any questions, the plaintiff respondent will rest on its briefs.
Thank you so much.
Thank you.
46th Street leaseholder versus Hercules Corp. You may proceed, counsel.
Good afternoon, Your Honors. Jeffrey Goldman on behalf of Plaintiff Appellant. The issue is whether or not the lower court erred in denying our cross motion for summary judgment on a set of facts and law that, quite frankly, is uncontested. The issue before the court was only for liability. Damages was going to be at a separate hearing. There is no dispute before the court. Defendant intentionally and knowingly breached the law, intentionally and knowingly violated the contract, and as a result of those two intentional and knowing acts, resulted in DOB violations. As a matter of law, DOB was required to shut the gas off. As a matter of law, DOB was thereafter required for us to conduct a pressure test. There was nothing.
But counsel, while they were dealing with the pressure test, didn't it turn out that there were some problems with the actual hard wires there that may have been a result of, I don't know, negligence or something by your client? I mean, there were 10 different wires, and some of the gas lines, and some of them failed during the pressure test.
No, and you might be conflating two different things. There are 10 gas lines.
Right.
6 failed, 4 passed.
Right.
So there was nothing.
Is that a responsibility of you or of them?
Well, let me address that, because the law is, it was the proximate cause by defendant that resulted in the gas shutoff. It's only whether or not the superseding or intervening act, which may presumably be the gas risers, and I'm going to get to that, it was so unforeseeable that there was no possibility. And I defer, and I reference the Court of Appeals decision in Dedera.
Well, as a part of the laundry work, did these defendants have to, were they required to test the entire building's gas system?
No, they're not. And
Okay, so that if there is a failure in the risers, that really has nothing to do with them, since their work was strictly with respect to the gas lines or the laundromat.
respectfully, Your Honor, when somebody causes a series of events, whether they were obligated to deal with it in the beginning or the end, when you knowingly, intentionally cause a series of events, and the law requires a testing, that is when you look at whether or not there was a superseding. Look at the fact pattern that the Court of Appeals had in Derderian. The fact pattern in Derderian was that somebody was injured as a result of somebody driving who failed to take their medicine, crashed into a barricade that wasn't.
Okay, we don't have that situation.
I know, but
Counsel, here we have a situation where the defendant here was gonna renovate the laundry room that he had been operating for years under the prior owner, correct?
they were supposed, not renovate, they were supposed to install a sprinkler system and
Which is a renovation. Go ahead.
and install new gas equipment. The
Right.
law required them to install the sprinkler system first.
No,
Then
wait,
the
wait,
ga-
counsel, let me just say, the contract required them. They had no obligation under any law. You had a
That's-
contract.
Yes.
So when you're talking about Desiderio, which is not a contract case, and you're talking about what are my damages under the contract, right? How much did you pay them under the contract? Several $1,000s? Is it foreseeable? You're saying as a matter of law, it was foreseeable that they would have to pay for 2 years of 4 of 10 or 6 of 10
6 of 10.
of the lines not? You're saying that that's a foreseeable contract damage?
It's-
As a matter of law?
It's foreseeable
As a matter of law.
as a matter of, okay, I'll tell you why. Because when you have a series of events that take place, and it's somebody who has engaged in bad practices over the course of time and knew before they undertook that work, knew that there would be a gas shutoff if what they did
Well, where does the
violated.
fact that there isn't a separate gas shutoff just for the dryer room, where does that figure into all of this? Had there been a separate shutoff just for the gas for the dryer room, a lot of this would never have happened.
It may not have happened. There was no obligation for us. In the record, it was defendant in 2014 that was supposed to put in this separate shutoff. There was an application filed by the defendant's plumber in 2014 to put in a separate shutoff, which they did not do. And if you
Well, we don't have the record on that, so I don't know whether the prior owner was just cheap and said, no, don't do that, I don't want to do that, I'm going to sell the building anyway.
Your
Right?
Honor, we could say a lot of what ifs.
Right.
But what we
But we're
know.
not dealing with the 2014 contract, we're dealing with this contract.
Correct, but what we do know is that they have a history of doing these illegal alterations, but for their illegal work, which was knowing and intentional, the gas would never have been shut off. We know that. And for the court to find, and the fact issue the lower court found.
I don't know that.
Well, the record shows that, and the record is complete because there was no proof of any deficiencies in the gas line. There was no smell of gas leaks. There was no problems with any of the gas piping whatsoever. That's unrebutted.
Okay.
20 years of that proof.
You have time on rebuttal. Counsel, you may proceed.
May it please the court, Glenn Kaminsky with the firm Amity Demers McManus, counsel for the respondent. And I would respectfully ask this court to affirm the decision of the Supreme Court denying the motion for summary
Well, in
judgment.
some respects, there's no question that you violated your contractual obligations. What's supposed to happen? The fittings you used on the gas lines, the sprinkler system, you didn't do things you were supposed to do. So what are we supposed to do about that?
Well, I would say that, first of all, the job was never completed, right? It wasn't complete at the time of the inspection. So they did the flex lines first, right? But eventually, they had plans to have the plumber come in and complete with the hard.
But you weren't
hard
supposed to
piping.
use flex lines. You were supposed to use solid lines.
Correct. And those were temporary lines. Everyone testifies. It's
I think your
temporary
bigger
lines.
problem is that you violated the contract from the outset by not getting by beginning the work before you had the permits in hand. So that by itself already has an automatic breach of contract there, just by that fact.
Look, do I have a great case of a breach of contract? I don't, okay?
Okay.
But am I the proximate cause of these damages? No. Steve.
Well,
Beckman testifies-
let's separate them out. The ECB violations, I don't know how you get around proximate cause for that. I mean, the other ones about the gas lines and everything else is a different issue, but there's really not a lot that you can say about your proximate cause for those ECB violations.
And what was the?
Except your argument that, oh my God, no one knew that the Department of Buildings would actually do their job and inspect. I mean, that's your argument.
Well,
that doesn't really go very far.
That's actually what has been the general, what has happened in the past, what Beckerman testified to. They never shut down a building before. This was the building that it started with. This is the building, according to his testimony, that this is how it started. This was a new regime, if you will, where things began.
Where they actually did what they were supposed to do and issued the violations. That's what I'm saying. That's
Right.
a hard argument
But
for you to
the
make,
violation-
that wasn't a proximate cause.
But what did they say? Repair, replace. And so eventually, that's all that needed. And what ultimately happened with those violations, right? They were dismissed after they repaired and replaced. So again, ultimately, we know issues of fact here on what plaintiff moved for. 386 or 388, Mr. Beckerman testifies that there was a separate shutoff for this laundry room. Okay, that alone, whether plaintiff wants to believe it's true or not believe it's true, giving the non-moving party every favorable inference, as this court well knows, there's an issue of fact. It can't be denied. The Dalen employees.
But doesn't the fact that there was no cutoff switch kind of cut both ways in that your client was the vendor who operated the laundry room for years before this owner? So I would presume your client knew there was no shut-off valve in the laundry room.
He testified, in fact, there was a shut-off valve. And in fact, he sent an email, record 1127, July 3rd, the day after, saying, why didn't you just shut it off at the shut-off valve? And then even record, let me see, 413, Ms. Furmansky references multiple meters in her email, which belies the argument made in the reply papers of the plaintiff at 1139 of the record that there was only 1 meter at that time. Again, giving every favorable inference to the non-moving party.
No, but counsel, doesn't that go to damages? And as counsel pointed out, he's not asking for, I mean, maybe there are no damages. He's talking about liability. And if you're talking about liability for breach of contract, you've admitted that you didn't get the permits, and that as a result of that, at a minimum, you got ECB violations. And that's what the first cause of action is, correct?
Well, the cause of
So on
action for breach of
liability,
contract.
I don't know how you could deny the summary judgment on liability on just liability. It may be that at the end of the day, there were no damages from that, but
Well,
the
because
question
one
is
of
whether
the,
we should grant summary judgment on liability.
as the court pointed out below, and I think is perfectly appropriate here, that one of the elements of a breach of contract still incorporates a proximate cause element. And without it, you can't have these damages asserted for $1.6 million for these risers. When those 6 of 10 risers fail, that's not our fault. We didn't work on the risers.
That's the second cause of action. The first cause of action is you didn't do what you were supposed to do and you got ECB violations because of it, and that caused me damages, right?
But I see it differently, but I understand what you're saying, Your Honor.
Okay.
And then I will respectfully say that the motion was untimely, okay? And the court below never addressed it, and we are allowed to address it before this court. And here, basically, all I'm saying is, if a court says something, it should mean something. And if a court tells you you have to move by December 29th, 2020, and you don't do so, and the court says, oh, and you, the parties, you can't extend this time frame. You can't extend the time frame. And then you can't come in and say, whoa, but it's the same motion, but say, oh, I got a separate statement of facts, and that separate statement of facts you didn't respond to, and so then I should ignore the original motion to begin with. All of this is just an untimely motion, and none of this should be looked at substantively.
Thank you. Counsel, you have 2 minutes.
Just a couple of things. There is no affidavit from their master plumber who worked in this building in 2014 and 2016. He is the person who would know if there's a separate shutoff valve. He is the person who would know whether or not things were properly done. The absence of that master plumber tells you everything because the affidavit from the super who was there for 20-plus years showed there was no separate shutoff valve, and the fact that someone runs down in an emergency on July 5th or whenever he came down and says, oh, there's no shutoff valve, doesn't say, or there was a shutoff valve, and doesn't say where it was. And our expert affidavit says shutoff valves follow meters, and there's only 1 meter, and therefore that was where the shutoff valve was. I'm going to leave you with one other point. The Court of Appeals in Haynes and Derderian said proximate cause in superseding events. You have to look at public policy. Page 33 of their brief says the same thing. It has to at least look at the facts. When you look, and this is not a negligence case, when you knowingly, intentionally do something, not once, but in a 4-year period of time, 95 times, when you testify under oath that a violation is not a breach of the law, when you testify that flex, which results in the highest severity level, is merely incompliant material, when you testify under oath that what's the big deal? We just pay a fine. That's what they did in 95 other instances. There were 6 shut off in buildings before June of 19. If public policy is not going to say that Hercules is a bad actor, and you're not going to say that they're liable for the damages that flowed, you are condoning and encouraging that behavior. Because there's nothing that's going to stop them from doing illegal connections in every building, no matter what, because only their liability is fixing, paying a fine, not a big deal. Let the owner bear the cost of pipes. That's not good public policy in a city that fears gas explosions.
Thank you so much. Tinty versus PMG 2310. You may proceed.
May it please the court, I'm Lindsay Bechtel from Litchfield Cavo. We represent defendants appellants PMG 2310 QPS LLC and QPS 23 Development LLC. Plaintiff respondent was struck by a concrete hose on September 10th, 2015 while working at a construction site in Queensboro Plaza. QPS owned the building and self-managed the development of the property. Plaintiff moved for summary judgment, seeking liability on all of his claims under labor law. We cross-moved, seeking dismissal of all claims. Judge Walker in Bronx County issued an...
How high up did this house fall?
One of the incident report says it was 10 feet. The plaintiff himself says he doesn't know.
What had been supporting this house?
That's also something that's at issue. The crux of our appeal is plaintiff's testimony that the people that was on top let go of a hose and it fell right close to me. That's how he said it. And so although the incident report says reportedly it collapsed under a guardrail, plaintiff's testimony is that it could have been in use at the time and not collapsing.
However it fell, isn't there an obligation to secure that hose if it's a hose that can fall 10 feet in height, a distance of 10 feet, isn't there an obligation to do something to secure that hose?
We're arguing that there are questions of fact regarding the size of the hose, how heavy it was, if it was actually filled with concrete, and whether it was being used at the time. There's a possibility.
There seems to have been evidence here that it was being used even if not at that exact moment, so it didn't have lots of concrete in it, which would have made it even heavier, but that they were doing something on top of a parking area, I think, and they were putting concrete on, and it was, the testimony seems to show that, or that at least plaintiffs said, and I think there was other testimony, that it was above him and that it was leaning against the guardrail, and the guardrail collapsed and the hose fell down and something banged up and hit his hip. I mean, how do you allow a hose, whether it has full of concrete or not full of concrete, to lie on a guardrail that clearly was not strong enough to hold it?
We're arguing that there's evidence on the record that it wasn't lying on a guardrail, that the plaintiff said that somebody was using it at the
He
time.
denies
Perhaps it
saying
was just
that.
being moved from one
He
point to
denies
another.
saying that.
He says the people that was on top let go.
You read that already. I heard you.
Okay.
I don't believe that he agrees that that is what he said.
It was his testimony, so it's our understanding that it's part of the evidence. And the incident report says.
Well, no. I mean, that was one thing he said, right? But then later on, he said, actually, I really don't know how it happened, right?
He says he
did say
wasn't
that,
looking
right?
up.
So, and
He was looking straight ahead.
Oh, I can understand that. I mean, you can't accomplish your work if you're looking up the whole time. He was working, he was doing something else, and this fell on him.
Well, we're arguing.
This isn't a 1-inch garden hose that fell. You're talking about, I mean, there's evidence that it's 6 inches in diameter with a metal head to it. If it falls 10 feet, isn't there an obligation to make sure that it can't fall?
Well, plaintiff's respondent's expert discusses a type of hose and he explains he doesn't know the weight of the hose, and he just picks one type of make and model despite not knowing what it is. So we don't know.
Doesn't the evidence show that the hose weighed between 45 to 77 pounds? Yep.
The plaintiff's expert looks at a type of hose, GHB Enterprises, I believe, but he doesn't
did you
provide
submit any evidence to say that the hose only weighs a pound?
No.
I didn't see that.
No,
So-
we don't have an expert. But we're arguing that it's not foreseeable, and there's questions of fact regarding whether the load needed to be secured at the time.
Well, why would it not have needed to be secured? I didn't exactly get your argument on that.
Perhaps it was being used at the time. Perhaps it was being just moved from one point to the other and not part of concrete pumping operation.
But that wouldn't matter, right? Whether it was being used at the time or not, if an object can fall on workers below, you have an obligation to secure them. That's the whole public policy behind labor law, right? But you'll have time on rebuttal.
Okay.
Good afternoon, excuse me. Good afternoon, Your Honors. Matthew Rice, plaintiff respondent. I think a lot of what you guys have said here is absolutely correct. I've raised all of these points in opposition. He was a covered worker. The tube was material to the work. I did get an expert. Appellants did not. They had the option to do all of those things. The testimony is pretty clear.
What's your response to the point made by counsel that they dropped the hose?
Well, whether they dropped it or not, they're still working from 10 feet above them in an open area. It should have been secured. You could have used a chain fall. You could have used a lot of things. I mean, these things are not supposed to happen. That's the purpose of Labor Law 240. And if it was too heavy for people to hold it, then it was not properly secured. If their argument is that the people were the people securing it, it's not adequate. We have an expert to say that it was improperly secured. And any of these things, I mean, Ms. Bechtel is saying, well, it could have been, or perhaps, or we think. Well, none of that is actually evidence. I mean, we could have thought a lot of things. I said to their witness, Mr. Carlucci, do you have any reason to refute what's in this accident report, that it was hanging on top of the guardrail? He said no.
That accident report was prepared by whom, by the way?
That was performed by, that one was done by the site safety contractor. Paul Claising was the gentleman who filled it out. He was no longer employed by them. So what I did was, in efforts to have it be admissible, I got an affidavit from the owner of the company saying that this is our accident report. He was no longer employed. We did subpoena him. I tried to lay out all the proofs to make sure I went through every effort I could to do that. And I did ask their guys and say, you know, did you do this? And he said, this is what we have. And I wasn't there. Okay, you weren't there. I mean, listen, he didn't have a fusion surgery. He was frightened. This isn't a case where he's trying to make it into something it's not. He didn't really speak English very well, so some of the questions were what they were. And to Your Honor's points, I mean, obviously people aren't looking up to see what's going to fall and know exactly how it happened. It doesn't work like that. These 51st Street crane collapses. I mean, the crane falls. Do you know what happened? Oh, I don't know what happened. The crane fell. I mean, that's just kind of how these happen, and that's why you have 240. I was a defense attorney for a long time, and I mean, this is about as 240 as it gets. They cited Narducci and a couple of other things. I mean, Narducci dealt with a pane of glass that was not material to the work. They cited...
But here it seems that this hose was certainly being used. Either it was resting for a while on something that wasn't going to hold it, or being used, and guys dropped it. That seems to be the two choices here.
Either way you slice it, Your Honor, it's
not Narducci.
It's not secured, and it hurts someone. I mean, those are the things you're supposed to try to protect of. I'm not trying to come up with, like, you know, well, we had a little linchpin that fell. That's the cases that counsel cited in opposition, saying it was akin to that. And this is not that. You know, whether it was 50 pounds, 75 pounds, there's pictures of it in my briefs. It's big. It hit somebody. It fell. That's not supposed to happen.
Thank you.
Thank you, Your Honors.
I just wanted to conclude by noting the court's opinion in Miseretti, where a firewall collapsed on the plaintiff, and the court determined that that was the type of ordinary and usual peril to which a worker is commonly exposed at a construction site. So if there is a question of fact regarding...
I believe in that case, the firewall was being torn down, right?
There were braces on it, and there was an issue about whether there should be braces or not on the wall, and there were not braces at the time of its collapse. So and the court found that it was not a 240 sub 1 case because it was an ordinary peril of the construction site. If there are questions of fact regarding whether it was on a guardrail or being moved from point A to point B and simply fell, wouldn't that be an ordinary unusual peril to which a construction worker is exposed to?
It's the usual peril that 240 sub 1 was enacted to safeguard against. But thank you. All right. Matter of the liquidation of Atlantic Mutual Insurance Company versus United Synagogue of Conservative Judaism versus Superintendent. You may proceed, sir.
Thank you. Good afternoon, Your Honors. May it please the court. My name is Joshua Mellon. I represent the appellant in this case. The Child Victim Act was adopted in 2019.
Ma'am, you can sit down. Go ahead.
To provide an equitable window for minors to bring lawsuits against alleged perpetrators and institutions that employed them.
The facts of this case is certainly, you know, you would say, well, of course, there should be insurance coverage. How does the insurance coverage get knocked out when it's first years later that they even become aware of this? But how do we get past matter of Jason?
Okay, so
seems to say that notwithstanding all of the factors that would point in your direction, seems to say, well,
so matter of Jason dealt with what I would call a non-atypical fact pattern. There are situations that there will always be when you have cutoff dates where there will be a claim that comes in after the cutoff date. In that case, you're talking about within the same month. Here, and therefore you had a policy that was in place, and you didn't have issues with respect to statutes of limitations. Here, you have an extraordinary situation. an extraordinary situation where the legislature creates an act and the ability to bring a suit for cases that were time barred.
But, you know, I mean, like, there's two things. You're right. They brought this action, they changed the law so that there would be a window for people who were abused or allegedly abused to make these claims, and we're all familiar with the act. On the other hand, there was a liquidation going on here, and at some point, there has to be an end to that, because otherwise it could go on and on forever. The legislature did not deal with this when they enacted the Child Victims Act. Shouldn't this be something for the legislature rather than, so we get all the issues here, but it seems to us beyond what we're able to do.
So let me address that. So first of all, the question presupposes that the court did not have any inherent power under the current statutory guidelines to do anything. Right. I would suggest to you that's wrong. If the court looks at insurance law 7432, insurance law 7434, and insurance law 7405, these are all deal with liquidation. In each instance, there's a provision that gives the court some input. 7432 deals specifically with time to file claims. 7434 deals with the distribution of assets and how it should be classified as a late claim or as a timely claim. 7405 deals with the rights and liabilities. In each of those sections, there is a sentence that says, in sum and substance, unless otherwise directed by the court. So there is a supposition in your question that when the legislature created the CVA, that they believed that they would have had to do that. Then they did do that in other instances. As counsel pointed out in their brief, on notices to the city, notices to the municipality, notices to the state, where those are conditions precedent, they made sure in those situations to exempt them. But these are sui generis situations. The legislature would not and could not envision a situation where they would give a hard and fast rule.
Have there been any other cases that fell into this category, or is this really
Well, I mean, this is the only one with respect to this, but from a generic perspective, if you look at the In-Ray Transit case, and another case we cited in our brief, In-Ray Union Indemnity, those are two situations in which the superintendent, on different issues, took the exact same posture, which is you have to have everything regulated. There has to be uniformity across the board. Now, I understand the facts of those cases are a little bit different. One had to do with post-liquidation interest. One had to do with the right, with the cancellation of a contract. But underneath all of that was the argument.
Transit doesn't really provide a roadmap to get you out of what, you know, on the face of it is certainly a great unfairness.
You're correct. It doesn't on its face because it's dealing with the contract right that I made reference to.
Right.
But what the Court of Appeals did say was that the law, the structure of the insurance fund, the superintendent and the fund, is not as inflexible as the superintendent suggests that it needs to be. I.e., there are mechanisms, there are ways we do not feel that we are rigidly tied in when there is a circumstance that warrants it. In that case, it was a contract that was not a policy that wasn't properly canceled. So it was an extreme situation. So the Court of Appeals said, no, I've got to deal with that situation, notwithstanding the concern that we're going to treat one person or one class of people a little bit differently than everybody else because the superintendent's goal is uniformity across the board. And the Court of Appeals said, no. There are certain circumstances in which we're going to step out of that, and we think we can, and we're not opening up this Pandora's box. So we reject philosophically this idea that we are constricted by the statute. The last thing I want to say is dealing with due process. There's a reverse due process argument, and you sort of alluded to it. The cases we cite legislative enactments where the legislature shortens the statute of limitations. And then it's like, well, okay, I had a right, now I don't have a right. What am I supposed to do? And the Court of Appeals, without going to or citing the legislature and saying, oh, well, legislature, when you shorten the statute of limitations, why didn't you provide for X, Y, and Z? The court says we have the inherent power to create a reasonable opportunity for that person who was now deprived of a right to take action. A reasonable period of time is what they talk about, however one wants to define that. So there is room, there is authority, whether from a statutory perspective, a case law perspective that deals with
Counsel, let me just say, you're not, I mean, the plaintiff still has their claim. The only issue is you're saying it's a due process violation that they don't have this particular pot of money to go after?
No, it's a due process that I now do not have a
The
liability
right to go after
carrier.
a certain pot of money as opposed to any other pot of money?
I've been paying premiums, and now my carrier, through no fault of my own, is insolvent, and now I get sued, and I no longer have that pot of money. I am now liable. That's why I said it's the reverse of it's still a due process, right? Because I'm paying premiums and I'm deprived of the benefit of my insurance policy
All right.
because of acts that I had nothing to do with.
You'll have time on rebuttal.
Thank you.
You may proceed.
Good afternoon, Your Honors. I'm Cynthia Borelli from Bressler, Emery, and Ross, and I represent the Superintendent of the Department of Financial Services in her capacity as liquidator of American Mutual Insurance Company in liquidation.
So, counsel, your adversary is arguing that the court does have some discretion in this case, that the cases say, you know, unless otherwise directed by the court. How do you address that issue?
First of all, the statute, which is 7432, in fact, does allow for a bar date to be changed. And in fact, it has been changed in this very insolvency. Statute sets a 4-month bar date, and on application of the superintendent, the bar date can be moved, and it was moved here. It was moved very early in the liquidation before there were vested rights by other parties who brought timely claims and went through the NOD, Notice of Determination process set forth in the adjudication of claims order entered by the liquidation court.
But at some point, I mean, but their right didn't exist at that time, did it? I mean, the plaintiffs who brought the case against the petitioner here, or the plaintiff here, that they didn't even have that at the right time, did they? They couldn't have brought that at them because they had no claim to bring up, right?
But respectfully, Honor, that's the point. The only time that the insurance liquidation laws allow for a bar date to be moved is early on in the liquidation pursuant to that section of the law that I just cited.
And if things happen 2 years or 3 years later, it's too bad, that's the way it happens.
The case law in the state does say that. The Jason case very clearly,
On its face, there's a great unfairness taking place here. You put a bar date in 2013, and then a right gets created in 2019, and a cause of action is created for which there would be insurance, but because you put in this 2013 bar date, their insurance is gone.
Their insurance was gone at the date of liquidation, respectfully, Your Honor. But more importantly, no right was created vested in the synagogue. The right was created vested in the child who had been a victim of alleged victim of sexual abuse, and the right that he or she had was to revive their claim, and that right
happened
has been
in
satisfied.
2019, 6 years after the bar date.
That's right, because the statute clearly allowed the benefit to that class of individuals, those who were less than 18 at the time of alleged victims of sexual abuse, physical or psychological injury. The synagogue is not a beneficiary of the statute, therefore derived no rights from the statute, Your Honor.
Okay.
The liquidation laws which establish the bar date, Your Honors, have been enforced for a very long time. They're a critical tenet of insurance insolvency, and they are there to benefit the whole, all policyholders and other claimants of insolvent insurers, not just those in this liquidation. And there are many other Child Victim Act-related claims, not only in this insolvency, but others in the state of New York and all across the country. And in the state of New York, the law is that the bar date is enforced and there is no interest of justice
You bring
exception.
up other states. Have other states done anything about this insurance issue?
Your Honor, the last time I looked, which admittedly was several months ago, there had been no decided cases. Other states have different statutes. Our statute, although there's a uniform system to address insurance insolvency, there are differences. And in this state, there is no interest of justice exception in the statute, and case law expressly, this court, this very court, held in Jason that there is no interest of justice exception. And the situation...
You said earlier that there have been some cases where the bar date has been moved.
There was in this case.
There was in this
early on, and it was over a clear notice issue, and it was on certification by the superintendent before there were any rights vested, before we could upset the apple cart, before those who had their claims adjudicated and valued, and before 11 years of liquidation, 11 years of a massive group of people waiting to get paid. There is no reason in this case, there's nothing that mandates that you set aside this bar date, and we respectfully request that you honor the decision of the Supreme Court as well as the referee below.
And those comments, therein lies the public policy why these dates are held firm in terms of
Yes,
liquidation
yes, because
of insurance.
it's a broader issue that impacts many, many people across many, many insolvencies, not just this insolvency, not just these particular insureds or claimants.
Thank you.
Thank you, Your Honor.
Counsel, you have 2 minutes, and I let you go over on the front end, so I'm going to hold you to your 2 minutes now, okay? All right.
And so what you just heard was exactly what was argued in front of the New York Court of Appeals on transit and on union indemnity because of this uniformity that we need. I find it ironic that, as was pointed out here, when the superintendent felt that there was a need because of notice issues early on, that they actually moved the bar date. They actually went to the court and moved the bar date. Why couldn't the superintendent, under this very strange fact pattern where you have rights created that didn't exist before, have gone to the court under a need, there's a new event, and done the same thing? They were so concerned then with respect to notice, but they're not concerned now. They're not concerned now because again, they talk about this uniformity and everything that needs to be worked out. There's nothing in the record, and there's been no development in the record that suggests that policyholders are going to be injured because now a couple of other claims are going to be put in. There has been no articulation as to numbers of other claims that would happen in connection with this. And finally, it's further ironic that the Department of Financial Services, once the CVA was passed, came out with a directive and said to all the insurance companies, you need to proceed in good faith. You need to proceed because we understand that notwithstanding the victim is the victim, if there are no assets to pay the victim their damages, then it's a Pyrrhic victory. So insurance companies, you're on notice. This is the Department of Financial Services in the directive that we put in the record, directing them to act in good faith and to honor. Why wouldn't that same directive be in place with the superintendent of insurance? You've got one part of the insurance department talking to the other part of the insurance department, and a statute that created the superintendent of insurance, and a statute now created these new rights that have now exposed all of these people, and ultimately we want to worry about the victim. So if we want to worry about the victim and we're concerned about them being compensated, then you have to be able to have insurance to do that. Otherwise, it is just a Pyrrhic victory. Thank you.
People versus Maria Rodriguez. You may proceed.
Good afternoon, Your Honors, and may it please the Court. Alexandra Mitter on behalf of Maria Rodriguez. The lower court here correctly found that Ms. Rodriguez was the victim of substantial domestic violence. She has experienced a lifetime of truly unimaginable abuse. The court also correctly found that this abuse was a significant contributing factor to Ms. Rodriguez's participation in the murder of her dear friend, Luis Rodriguez. That but for her longtime abuser's coercive control the night of this incident, Ms. Rodriguez would not have been involved in the crime. Where the lower court erred, the lower court's mistake is in her assessment that a 20-year sentence for this admitted victim of domestic violence was not unduly harsh under the paradigm-shifting remedial DVSJA statute.
She has now served 15 years, more than 15 years?
She has served more than 15 years, Your Honor, which is 3 times the maximum sentence under the domestic violence statute. To be clear, this is a near maximum term sentence that Ms. Rodriguez has been sentenced to serve, and I've heard absolutely nothing in any of the respondents' papers about the penological purposes that will be served by continuing to incarcerate Ms. Rodriguez. She has done everything that we ask a person in prison to do. She has taken courses related to domestic violence. She has tried, despite very severe cognitive disabilities, to improve her education. She has gotten baptized. She has worked consistently, though it seems to have cost her her hearing. There is nothing that serves the people of the state of New York by keeping Ms. Rodriguez in prison, away from her siblings, away from her children, away from her grandchildren, who she has not gotten to meet in person. And so, unless Your Honors have any further questions.
Just remind me of what have you shown in terms of her support system if and when she would get out?
Absolutely, Your Honor. Ms. Rodriguez's elder sister, Angelique Diaz, lives in New York City. She is a pastor, and she has, in papers we submitted to the lower court, acknowledged that she's willing to house Ms. Rodriguez, support Ms. Rodriguez, provide sort of emotional and financial support to Ms. Rodriguez. And Ms. Diaz herself has undergone a series of very significant medical surgeries in the last several years and is looking forward to having Ms. Rodriguez home with her to actually care for her in sort of a more physical way while she supports her sister upon her release from prison. She also has the support of her elder son, Rafael Saz, who, though he lives in California, is incredibly excited to support his mother upon her release, cannot wait for her to meet his wife, his grandchildren, learn about his life.
Is this the son that was being threatened on the evening in question?
No, Your Honor, that's her younger son, who unfortunately, as a result of his continued sort of being under the thralls of Ms. Rodriguez's abuser, Ms. Rodriguez has not been able to maintain a relationship with her younger son. Her older son was the one who was out that night when this incident occurred, and who Ms. Rodriguez sort of pleaded to be allowed to wait for him to come home, lest she have to leave this 16-year-old, in the streets.
The younger son was the biological child of the abuser, is that correct?
That is correct, and so...
but the older son not, he was from...
The older son is from a prior relationship, and so when Ms. Rodriguez learned that Mr. Fernandez had died, she begged her abuser to be allowed to take both sons with her back to New York to stay with her sister and, voluntarily take the blame for this crime. Her abuser would not let her take the younger son, and ultimately, no one got to go back to New York because they were arrested in Florida on this crime. Ms. Rodriguez's older son being arrested with Ms. Rodriguez herself and her abuser, which explains the false confession that she wrote and signed related to this crime. Ms. Rodriguez deserves this court's compassion. She has been in prison for 15 years. The additional couple of years that she has left to serve under this pre-DVSJA sentence serves absolutely no penological purpose, and we would respectfully ask this court to give the statute its intended effect and resentence Ms. Rodriguez. Thank you.
Thank you. You may proceed.
Yes, Your Honor. Good afternoon, and may it please the court, Paul Anderson for the people. What this case boils down to is whether the lower court improvidently exercised its discretion when hearing all of these arguments, seeing Ms. Rodriguez on the stand, seeing the decedent's son on the stand, seeing Ms. Rodriguez now, in present day, describe the events that occurred and how they affect her, and still minimize that conduct, and still, even incorporating the 440 hearing prior, denied the conduct that the lower court credited of her threatening to take the decedent's green card and burn them, threatened to go to the police and say, I'm going to tell you that you abused me. And the lower court credited that, credited Ms. Rodriguez continuing to minimize her actions here, continuing to say, I wasn't in the room, I don't recall this, I don't recall that, I got the small knife, I stabbed. I thought maybe I would try to get help, but then respond with, well, I didn't have the opportunity to. And most importantly, at the very end of the hearing, when I asked, well, okay, you thought he was alive, the decedent, you tied him up, you left him broken, stabbed.
Well, she didn't tie him up. He was already tied up when she was brought into the room, right?
According to her testimony, yes, but she left him tied up, beaten, stabbed, tried to clean the room a bit, left him behind, said, okay, I thought he was alive. So I asked, okay, so you ran to Florida, you thought he was alive. Do you think that he would have told the police that you were involved? And she said, you know what, no, he would not. He would have said, he would have stayed on my side. And this is a domestic violence case. And yes, Mr. Rodriguez was a domestic violence victim, but she was also a domestic abuser, and that's what the lower court found here, and that's why we're not just focusing on the nature and circumstances.
She was a domestic abuser?
Yes, she abused Luis Fernandez, the decedent, and the lower court credited that of the fact that that the decedent called his son, who testified at this hearing. It was admitted in reliable hearsay, which is allowed in this, saying, my father called me a couple of times. She is beating me. She's threatening to take my paperwork, my green card, my passports. If I want to go to the police.
Talking about Omar's testimony, which came in without objection. So what happened to Gonzalez? He was also charged, right?
Yes, Your Honor. He was charged and acquitted. In the 440-10 hearing, we went into detail of how we were trying to have Ms. Rodriguez testify and for the people and maybe to lower her sentence, but she didn't. She, I think, testified that she was unaware of the negotiations beyond there. So it was an acquittal.
I think Mr. Gonzalez must have had a much better lawyer than Ms. Rodriguez.
Well, we also, I'm sorry to interrupt. Well, we also had the statement, the false confession, where she admits now she's lied. And so this is a defendant who knows when to lie, knows how to lie, and I think the court below, while not, I think, was generous in its credibility finding here and just saying it was just vague and vague.
It's I'm listening to you, and it's as though you can so comfortably compartmentalize this woman into these two different human beings. One that's a beaten domestic abuse survivor. The woman was repeatedly beaten, raped, sent to the hospital at the hands of this co-defendant. But he walks. This whole thing happened because of Mr. Rodriguez.
Well, Your Honor, we're not.
Mr.
But, Your Honor, once again.
You know who I mean.
Yes,
the co-defendant, right?
I understand, Your Honor, but still, we have this gray area of what exactly occurred that night, where she had the opportunity to
Again, I understand your arguments, and you want to compartmentalize them. She doesn't get to put her abuse on the shelf while she's dealing with this outrageous situation where her lover is telling her to stab her friend to death. He didn't do it. He told her to do it.
That we presume the jury discredited in his trial. Once again, we have to compartmentalize this because the only source of information that would give us that overlap was her testimony or Rafael Saez, the oldest son's testimony here. So it's their burden to show this. I agree, it is compartmentalized here, but because we do not know how this actually overlapped, because there are only 2 people or 3 people that could have told us, and when she was on the stand and had the opportunity to say, yes, that was part of the scheme, but once again, I had to do it. Yes, I was part of the scheme. I know he was dying, but I was so afraid. Instead, I wasn't in the room. I wasn't there. I was trying my best to get away and call someone. I don't recall taking money, and then when confronted every single time,
Well, you have videos of her taking the money.
Yes.
At this point, is the issue that before this court just a straight matter of our exercise of discretion, whether or not to reduce the sentence?
No, Your Honor. You'd have to find that the lower court improvidently exercised its discretion because it's different, because of the way the 440-47-3A comes up, it's not the sentence itself up for review, it's the order denying resentence. And so that's how this court has decided in People v. Rengel, and the second department recently decided the same one of using that provident exercise of discretion fact. But still when we have, even in the prior 440, on page 554 and 555 of her saying, no, I've never threatened Luis Fernandez, we never had a fight, I've never threatened to burn the passports, and then we have the testimony that the lower court credited from the son that she was an abuser towards this person in the lead up to it. And so that's why when we look at the character of the Ms. Rodriguez here, it's not just that we're looking at the nature and cause of the crime, we're looking at what the benefit she got from the programming that she successfully completed, any insight into how her actions that night, any real admission of guilt here. And honestly,
Counsel, wasn't there testimony from a domestic violence abuse expert explaining exactly why that testimony occurred?
In the first 4, Dr. Wanda Levy testified and had it in a report.
And isn't that basically why her sentence, the conviction was, she was granted a vacation of her conviction?
That was under an ineffective assistance of counsel.
Right, yes, I mean, that's technically why, but clearly, so why didn't the lower court accept that testimony which caused her to have her first conviction be reversed? Why didn't the lower court credit that testimony as a reason? I mean, obviously, the statute takes into account that people who are domestic abuse survivors do terrible things. That's the whole point. To say it's terrible is basically to ignore the statute.
Yes, Your Honor, and I'll point out it's the same judge for both that heard the testimony from Dr. Levy and that denied it here. And yes, the statute takes it in mind, but once again, it's also the first consideration in the list of considerations. And finally, what changed the mind was the hearing, the new hearing that came out here, including the testimony of the decedent's son, who had this additional facts that wasn't in the first hearing, and then all combined together really painted the picture that this wasn't a person that warranted DBSJ.
You put a lot of weight on that son's testimony. My recollection of the record is that he maybe had 3 communications with his father over the years preceding his death. So it is what it is.
But
I
he was
thank you.
detailed.
Your time is up.
Yes, Your Honor. Thank you.
You've got 2 minutes.
Thank you, Your Honor. And I would just add that the testimony of the victim's son was also precluded at both of the 2 trials as unreliable hearsay, but in the interest of...
Was it admitted without opposition?
No, we objected to it strenuously at the hearing.
At the hearing, the last hearing.
At the 440-47 hearing, we objected to the admission of the testimony strenuously. It was subject to letter briefing prior to the hearing, and the court ultimately decided that in the sort of broad interest of the...
But on appeal, you're not arguing we should be considering that testimony?
It's not a decision that we are contesting, because
let me just ask you the same question I asked the Assistant District Attorney. If the court did something about this, there has to be a finding that Supreme Court improvidently exercised its discretion in failing to grant relief, is that?
I believe that this court has its own independent sentencing discretion here, but nonetheless, it is quite clear that the lower court abused its discretion in the determination that the sentence was not unduly harsh. As Your Honor pointed out, the court essentially ignored uncontested expert testimony by Dr. Wendy Levy explaining precisely the problems with the prosecution's argument. Ms. Rodriguez reacted in sort of the immediate aftermath and during the crime itself exactly the way we would expect a victim of domestic violence to act. She was in sort of mechanistic survival mode, just trying to get from one stage to the next and doing the best that she could. And you know, the respondent's complaint and the lower court's complaint that Ms. Rodriguez, didn't have a great recall for dates or times or durations about
as to what happened during the course of the crime, our only source of information really is the defendant. And I'm not questioning that she was the victim of domestic abuse by Gonzalez, but and her version of events don't always match up with the facts.
I think to the extent there's any incongruity, Your Honor, it is the result of asking a woman who has suffered severe domestic violence to recount something that happened 15 years ago, an incredibly traumatic event in a life of trauma, to ask her to recount the details, the precise details of something that happened, a decade and a half ago. There are going to be some mistakes.
The three withdrawals of funds, that's sort of like a pretty central aspect of that, of what occurred here, so.
But that would have happened right after she was forced to kill her friend. Am I right?
It would have happened within the hour, yes, Your Honor. And she never denied that she withdrew the funds when being shown the video. She says, I guess that was me. I just don't remember. She's not trying to minimize her conduct. She was trying to do the best she could with an IQ of 70 to remember something that happened nearly 2 decades ago. There are going to be mistakes, and with all due respect to the lower court, that is not a reason to deny Ms. Rodriguez sentencing relief here. Thank you, Your Honors.
Thank you. People v. Phyllis Tate. You may proceed.
Good afternoon, Your Honors, and may it please the Court. I'm Adia Davis, a Columbia Law School extern on behalf of Appellant Phyllis Tate. I'm going to address the 2 for-cause challenge denials today, starting first with Mr. Kyle Elliott, who explicitly expressed bias towards law enforcement and did not give adequate assurances that he could be impartial. So Mr. Elliott candidly acknowledged to the trial court that he knew many law enforcement officials, and when asked by the court whether this would affect his ability to be impartial, he said, I am definitely biased towards law enforcement. Given that Mr. Elliott expressed this bias very explicitly, it was the court's burden to then receive unequivocal assurances of his impartiality. The court that the question asked was whether Mr. Elliott would be able to just evaluate the testimony of law enforcement officials he knew was lying.
Was there any time during which, the conversation between the court and this particular juror, that the court was able to elicit an unequivocal assurance that the particular juror would be fair and impartial and would be able to put aside his connections to law enforcement people he knew?
No, Your Honor. First of all, Mr. Elliott gave an equivocal answer to the one question the court did ask. He said, if I'm understanding your question, I wouldn't, which didn't provide an unequivocal assurance.
Not very unequivocal, right?
Exactly. And in addition to that, the court never really asked Mr. Elliott anything other than the one question about officers he knew was lying. The court didn't ask if Mr. Elliott could evaluate all officer testimony the same as non-officer testimony. So we just don't know if Mr. Elliott would be able to evaluate all law enforcement testimony the same way.
And it wasn't just that he was friends with police officers. Didn't he live with an assistant district attorney?
Yes, Your Honor. He had several connections besides just police officers. Okay. And then turning next to Mr. Gavriluk, the prospective juror who said on the record, and the record supports, that he had very limited English proficiency. Mr. Gavriluk stated in response to the court's question of whether he had understood general instructions during jury selection, whether what he understood, and Mr. Gavriluk said that he didn't understand everything to that point. He specifically said not exactly.
Didn't he estimate that he understood about 50% of what was being said?
Yes, Your Honor. He said he understood about 50%, and then when the court started to further question Mr. Gavriluk, it was further apparent that he didn't understand exactly everything that was being asked of him. For example, the court was asking him biographical questions such as where he had, how far he'd gotten to school, and Mr. Gavriluk responded by saying school in Russia instead of providing a specific grade level or level of higher education. And so if Mr. Gavriluk wasn't able to understand the basic biographical questions or to really understand what the court was instructing, at the very beginning of jury selection, it's even less likely he would be able to understand the complicated instructions about things like reasonable doubt, to understand expert arson testimony, and to really interact with his fellow jurors during the jury deliberations. And if there's no further questions, thank you, Your Honors.
Thank you. You may proceed.
Thank you, Your Honors. Good afternoon. Andrew Seawald for the people. First, with respect to prospective juror Elliott, the court asked the prospective juror a question that ultimately was, you would be able to evaluate? And if you look at the context of that question, it was whether the prospective juror would be able to evaluate the testimony of a police officer that appeared not to be telling the truth. You would be able to evaluate, and the prospective juror said...
Is that an adequate question in the light of what transpired with this juror?
Well, the juror said, I would be able to. Now, look, there's a lot of back and forth that can
What does it mean to be able to evaluate, counsel?
What does it mean? It
Yes.
means to...
Does it mean that I'm able to put aside my biases in favor of the police? Is that what it means?
Yes.
Or does it mean something else?
No, in this context, it was that the juror would be able to put aside...
But that's not
Why
what
wasn't
was
that
asked.
asked? That should have been the question.
Well...
That's unequivocal, but that was not the question. It was
Look,
something totally
I would concede, I readily concede that the judge could have asked this question in a much clearer way.
Right.
There's no doubt about that, and that's...
And the people could have helped him to ask the question in a
Absolutely,
better
and so
way.
could the defense have.
But it's not the defense's job to clean up a juror who they think is biased. It's the prosecution. If you want to keep that witness, then you've got to make sure that the record shows that this prospective juror is going to be fair and impartial and set aside the explicit bias he identified.
But it is the defense's burden to sustain, to create an adequate record for a cause challenge. That is the defense's burden in this.
And you don't think that the witness saying, I am biased towards the police created an adequate record?
Not given the subsequent...
The subsequent question, could you tell if someone's lying or not just because they're a police officer? You think that adequately resolved the statement, I am biased towards the police?
Yes, Your Honor.
I don't know. As a trial judge for many years, I would find that a hard sell.
I mean,
hard sell?
I think look, I would prefer that the record was much clearer, obviously. But I would also say that in any oral proceeding, as this necessarily is, there's lots of back and forth. People interrupt each other, and even judges don't always phrase things in a way that reads perfectly clearly.
And isn't that, so when we're on appeal and we read this mess, right? So we're stuck with this mess as well as you are. And if the witness says, I am biased towards the police, and the trial court doesn't say, can you put aside that bias, how can we be assured that this witness shouldn't have been excused for cause? Because that subsequent question really had nothing to do with bias. It had to do with whether the witness whether the prospective juror knew how to tell how they evaluated whether someone was telling the truth. That's not necessarily the same thing, correct?
Respectfully, Your Honor, I disagree. The question was whether, despite the bias that the prospective juror had, the juror would be able to evaluate any police witnesses fairly. And the answer was, the prospective juror gave was, I would be able to.
No, that wasn't really the question anyway. The question was, if they are not telling the truth and they happen to be a police officer, are you going to disregard that? That was the actual question asked.
Right.
So that is not, can I put aside my bias in this trial? That's just, a question about, do I know how to evaluate the truth regardless of whether someone's a police officer? And that's, even it's clear that the witness says, if I'm understanding your question, the witness didn't even understand. I mean, the prospective jury didn't even really understand what the judge was asking. So on appeal, how could we be assured that that witness shouldn't have been, based on those two questions?
Well, the fact that the questions that the judge asked came immediately after the prospective juror had said, I have a bias toward law enforcement, that by itself shows that the questions were aimed at whether the juror would be able to set aside that bias. And
even though the prospective juror himself asked, if I'm understanding your question?
Well, that's not an uncommon phrase that someone would use, and it's clear.
I have to say, on a trial, if I mean,
well, I would
trial
also,
judges here. I don't know that
Your
if
Honors,
someone
I need
said to me, one second.
I'm sorry.
I'm just saying, if someone said to me, if I'm understanding your question, that would automatically, as a trial judge, wouldn't you think that, boy, maybe I'm not coming across the right way, and I should rephrase that question?
Well, the judge asked, again, the next words out of the judge's mouth were, you would be able to evaluate. And I'd say that that has to be read together with what just preceded it. And I would just point out that this was not at all a police case. This was not a police credibility case. The defense made that clear from the very beginning. The only police witness to testify in this case was the 911 technician, and the testimony was completely undisputed. And even if the court wants to consider that the fire marshal and the fire department witness were also police witnesses, their testimony was essentially uncontested as well. So, and that's not a harmless error argument. The defense is saying that I'm trying to raise a harmless error argument. It's not a harmless error argument.
Do you want to address the second juror? Because you're over time, but I'm giving you a little more time. It's not a problem. I'm going to give you another 40 seconds to address the other juror.
Okay, with respect to the other juror, look, he had lived in this country for 29 years.
But that means nothing. I know a lot of people who have been here forever and don't speak English. So that being here 29 years, unfortunately, does not equal English competency.
That's true, but he could,
Counsel, as I read these questions, it was clear that this man did not fully understand what was happening, maybe every other word or so. It was clear.
But Your Honor, I would say that, look, someone in Russia, they don't use the same articles that we use. And so that, I think, explains.
Same thing happens with Chinese Americans.
Absolutely, of course. But he clearly could read English. He could read English, and that that understandably carried a lot of weight for the judge. He's right in front of the judge, and the judge is able to, as she goes back and forth with him, she's able to see that he's able to read the questionnaire. Someone who...
But this is not a documents case. This is a trial where there's going to be verbal testimony, so he's got to be able to understand what he's hearing.
Well, absolutely, and she's asking him questions but that he clearly understands as well. So as they're going back and forth, and I would say that reading English for someone who has a marginal grasp of the language would be a harder task than communicating.
Not if you're a taxi driver. If you're a taxi driver, you need to be able to read the signs in order to get to where you're going.
Well, they need to be able to navigate maps,
right.
Of course, but all of this is to say that with both of these jurors, if there was anything inadequate about the court's inquiry, it was the defendant's burden to speak up and to ask further questions. The judge gave the attorneys opportunities to do so with both of these jurors, and the defense didn't ask anything further that would have illuminated the problems that the defense is now alleging on appeal, and even the ones that they raised those problems below, but they didn't create a record that would substantiate those problems to the degree that this court should find that the trial judge, who these jurors were in front of, didn't exercise her discretion properly in denying the cause challenges.
Thank you.
Thank you.
And you have 2 minutes.
I just want to briefly address the point that it was the trial counsel's burden to push the court to ask further questions. And under New York Criminal Procedure Law, Section 270.2, all that's necessary to preserve claims for appeal is to object to the 4 cause challenges and then to exhaust all peremptories, and trial counsel did that. Trial counsel has no obligation to ask further questions of the prospective jurors themselves or to probe the court to ask further questions. It's the court's obligation to ask those questions and make sure that the prospective jurors are qualified to serve on the jury. Thank you.
Thank you. I forgot your name?
Adia Davis.
Ms. Davis, I want to thank you. You did a great job as a law student arguing in the appellate division. As Mr. Seawald, always, good to see you again, and thank you so much for your advocacy here today.
Thank you, Your Honor.
Okay. Dragonetti Brothers versus Verizon New York. I like that name, Dragonetti. Me too. They call me Manzanetti sometimes.
You're halfway there.
Halfway there, right. You may proceed.
Good afternoon. If it please the court, Eric Ortman, Kaufman, Dalowich, and Volek for the appellant, Dragonetti Brothers. Your Honor, this is a case. Your Honors, this is a case seeking payment from a utility for utility interference work in the context of work the contractor did in a public contract.
For there to be a liability on the part of Verizon for this, doesn't the city have to ask for this work to be done? And in this case, there was no request by the city?
Well, let me answer to the question in 2 parts if I can. First, there is an obligation for the utility to pay for the utility interference work. The utility has its private property on city land. It's a public contract that the contractor is performing. There's interference, in this instance, with the branches over the Verizon line.
But again, doesn't the city have to ask for it?
Yes, in this case, the city actually did effectively direct it through the contract.
No. The statute requires that if the utility is going to be required to pay, that the city must order them to do the utility interference work or allow the contract that they had with you as your client, to do it for them.
Right.
Isn't that the way that works?
That's not correct, and respectfully, this is not under the administrative code or a statute. This is a common law obligation, as we put in our papers.
Yes, but under your contract, you had to reach an accommodation with the utility to go forward on work that was not ordered, specifically ordered.
No, what the contract required was...
Counsel, I know the general terms of the contract.
Okay.
And that's not what I'm talking about. So if under that tree pruning contract, you found that at said location in front of Verizon's facility, that this particular tree should be trimmed because it's too close to the wires, right? And unless the city sent a letter to that company, to Verizon saying, this needs to happen, and either you do it or our contractor is going to come by and negotiate with you. That's the way it works. So if there is no order, and there wasn't one here directed at Verizon, correct?
Well, Your Honor, there was...
Did the city send them an order saying they had to do this?
The city did not send them a letter or anything of that nature.
Right, so there was no order.
No,
You had a contract to prune and to do this work, but you can't just go and do this work where there hasn't been an order and then say, oh, by the way, you owe me.
No, it is anticipated in the contract and by the common law. So the common law, and we've cited...
How is it anticipated? Doesn't the contract have to have a Section U addendum for this to happen?
No, it does not. And there are many, many instances where there's no Section U or no city work order out to do work where utility interference occurs and the utility is notified and has to take care of it and protect or move its facility.
And they have the
It happens
choice
in
to,
many instances.
counsel, and they have the choice to do it themselves or to enter into a separate contract with whoever has the city contract to do the work, correct?
Absolutely, and that's exactly what we're talking about here. This is not
Right.
an instance, let me be clear, please, if I may. This is not an instance where we're saying we're unilaterally going to do the work, we're going to bill you, and you have to accept it.
But that's what happened here.
Not at all. No, that's not what happened here.
Didn't they tell you, we are not paying for this work, don't do it?
No, that's not what happened, if I may.
Go ahead.
Based on the facts, and we've laid it out in the papers, but I want to make sure I'm clear about this. What happened in this instance is there's an article of the city contract, which is in many city contracts and is in both pre-printing contracts involved here, Article 15. And the city anticipated utility impact, utility interference, and it said in that instance, that is the utility's responsibility. The contractor has to cooperate with the utility. They have to notify the utility has to take the measures it deems necessary to take the precautions with respect to its utility interference. All the contractor did in this instance is notify the utility, hey, we've now been given certain community boards to perform work. We've noticed that there's utility interference. We need you to come down and assess this and tell us what measures you may deem necessary. Now, those measures could be, we're going to take care, there's no interference. We've looked at it, there's no interference. They could say, we've looked at it, but we're going to take care of it ourselves. Or we're going to bring somebody else in, or we're going to have you do it. It could have been any one of those things. The contractor didn't demand payment. It didn't unilaterally do the work. It notified, as it was required by the contract, it notified the utility, we see interference, we have to notify you. You now have an obligation to at least assess it, at least look at it. What if it's dangerous? The utility, instead of assessing it, said, we're going to construe deemed necessary to do nothing. They've acknowledged it in affidavits multiple times. They did absolutely nothing. They said, we're not even going to look at it. And in the oral argument that we had in the lower court, counsel acknowledged that if we actually had to deem it, if we have to actually look at the interference and we might deem it necessary, we probably have an obligation to pay. So the strategy was, we're not even going to look. We're not even going to do what
So
the
that
contract
allowed you,
requires.
so that scenario, assuming that's what happened, would allow you to then unilaterally decide to do the work and charge them, even though they didn't say, okay, you know what, you're right, do it, or you're wrong, don't do it. Here they said nothing, so you just could go and do it and charge them.
No, absolutely not. I mean, in this instance, in the absence of any direction whatsoever or any responsibility, they absolved themselves of all responsibility. They didn't even look. In that absence, we did the work because we...
Wait. But didn't they tell you not to do the work?
No, it's not that way, if I may, Your Honor, please. The contractor has to trim the trees anyway. They have to trim the trees in locations where they're directed under the city contract. In certain instances...
So aren't you getting paid by the city for doing that work?
We're getting paid by the city for doing the work related to the trees on the city property. However, where there's interference in those instances, which again is replete throughout all public contracting, it's a determined violation for the city to pay for the private utility line. So what they indicate, as they did in Article 15 of this contract, that it's the utility's responsibility, the contractor has to cooperate with the utility, has to notify the utility, and the utility has to then determine what it deems necessary.
And if they don't, which you say they didn't in this case, there's something that allows you to say, okay, I'm going to do it anyway and bill you.
Well, no, what we're saying is in that instance, in the absence of them taking any responsibility, and we've cited the Perfetto case that basically says, and it's a recent case, okay, and it indicates, I think it was 2014, and it's in the record, it indicates that under no circumstances can the utility, with the common law obligations it has, which we've spelled out, and there's dozens of cases that support the concept, utility has a common law obligation to take care, to either, to protect its facilities. In that instance, the utility cannot choose to do nothing. To do absolutely nothing. It has that obligation to at least assess and...
Okay, and what case says that?
That is the Perfetto case. Let me give you the exact site.
Yeah, I have it right in front of me. Perfetto also says...
Perfetto v. Brooklyn Union Gas, sorry.
The case also says, since the utility interference work involves the property of private entities, it is privately negotiated between the utilities and the contractors. Generally, with respect to interference work, the utility has the option of performing the work itself, hiring its own contractor, or using the city's.
That's correct. But what it does say is it doesn't have the option to do nothing. That's how it ends.
Yes,
It
but
says
where
it
does
can't
it
do
say
nothing.
where does it say that you have the right to make the repair without notifying the city that you?
I'm sorry, forgive me. It's not a repair that they're making that's outside of the contract. These are trees that they have to trim. The lines happen to be in the way. So when they have to take extra time.
Can you tell me where?
They're not doing separate repairs, in other words.
Oh, my Lord, never mind.
I'm sorry, Your Honor.
It's all right. You don't want to hear what I have to ask, so
No,
you
please,
go
I'm
ahead
sorry,
and keep
forgive me.
talking.
I just want to say they're not doing separate repairs. I wasn't sure if I was clear.
Okay. All right, you're out of time. I'll hear you on rebuttal.
Okay.
Have I completely misread all these briefs?
No, you haven't. And in fact, Your Honor, to jump in the fray, may it please the court, I'm Alan Kaplan, Herrick Feinstein, representing Verizon. There are two key cases here. The issue with the Perfetto case that counsel doesn't address is it has footnotes. And in the footnotes, it makes it clear that there were several directives by the DDC, the Department of Design and Construction, ordering the utility to perform work, which is consistent with the argument that we're making, that the common law obligation, which derives from the police powers of the state, requires that the municipality order, direct the utility to do the work.
So you had the right to just not respond to plaintiffs' request to do the work. They wanted to do the work because they determined that there was interference, utility interference with the trees that they had an obligation to cut down. So they let you know. You didn't say yes, no, you didn't do anything. They didn't have the right to just go ahead.
Well, the short answer is absolutely. And let me go a little bit further. It wasn't that Verizon didn't do anything. They concede in their briefs. They concede that Verizon took a blanket position that notice utility impact work was never necessary. So they admit that we told them that we weren't going to pay for any of this work. It's no different than a gardener coming to your house and saying, you know what, I think it's going to snow tomorrow. I'm going to come by and I'm going to plow your driveway. Well, I tell the gardener, no, under no circumstances do I want you to come and plow my driveway. Nevertheless, it snows the next day, the gardener comes, plows the driveway. Do I have an obligation to pay that man? I would say, no, I don't. You need to have a contract, or you need to have an agreement, or you need to have a prior business relationship, or you have to have an order from the municipality involved here. And they've conceded that there is none of that. If you read Justice Cohen's decision, he spells it out. This pleading is full of holes. It's a quasi-contractual case, and it is admitted by the plaintiffs that there was never an agreement, there was never an expectation that they would get paid, that there was no prior relationship which would have induced them to do the work or even think that they would somehow get paid. If you look at the contract gives total discretion to the utility. It says Article 15, whatever the contractor deems necessary. It doesn't give any conditions, it doesn't give any protocol.
Not whatever the contractor deems necessary, whatever the utility deems necessary.
Correct. And it's a common term. It's used not just in these types of contracts, but you could see it in many statutes. It's a language for discretion. So
is that our decision in Van Tulco, Inc. still good law?
it's absolutely good law.
And in that case, didn't this court say that consistent with the statutory language, the practice at the time of this project was undertaken was for the contractor and utility companies to negotiate the cost of the work, and only upon the city's issuance of a workout notice directing removal would the utility company be required to immediately relocate its facility.
That's correct. All of the statutes involved say that it has to be approved by the commissioner, and the commissioner being the head of the agency from the city that's involved. And, in fact,
And is that satisfied by granting a contract to the plaintiffs here?
absolutely not. Absolutely not, because there's no directive by the commissioner. And Van Tulco, in fact, is right on point, and it's a First Department decision, and it was the same set of facts. A private contractor, put the utility on notice, nothing more, and then did the work without the utility's approval. And this court said, you don't get paid, you didn't perform the work properly, and it doesn't comply with the common law. You'd be standing the common law on its head if you adopted the appellant's argument, because the common law right derives from the municipality's police power. It doesn't extend to private entities. And for those reasons, we think that Justice Cohn's decision should be affirmed. Thank you very much.
Counsel, you have 2 minutes on rebuttal.
First of all, I want to apologize for cutting off your line of questioning.
Not a problem. It's
wasn't
the
meant-
spirit of litigation. Go
I
ahead.
don't mean to be disrespectful.
It's okay.
Okay. First of all, Ventolco, to be clear, is very distinguishable. That First Department case is very distinguishable. In that instance, you had a statute involved. It was road work. The administrative code doesn't apply to this work, overhead trees. It's the common law that applies. Second of all, most importantly.
So may I?
Sure.
May I ask you, did you ever go back to the municipality and say, we need to do this on Verizon's behalf? Please issue a notice to Verizon?
No, what we.
Isn't that what isn't that what everybody contemplates? And isn't that what the contract contemplates? Isn't that what the case law contemplates that you'll do? If you think this work is necessary, you go back to the Parks Department and say, we can't do our work without either cutting down the trees for Verizon or having Verizon. Did you ever do that?
Yeah, there were discussions with the city, but let me be clear.
No, I mean, did you ask them to issue a notice to Verizon?
No, I don't know that the request was made for the city to issue a notice, because the way these contracts work, and that's why Section U doesn't apply. In an oral argument to the lower court, counsel explained what Section U is. Section U is for the mega projects, and he went into great detail. And if you read the lower court's argument, transcript, this is in the record, he indicated these are the big projects where they put engineers and they try to figure out what impacts might exist. They're knocking down a building, they're working on a city street, they're working with underground utilities that they're able to figure out. This is not that type of a contract. It is a material contract to protect the public so the trees don't fall down on lines during hurricanes. That's when this really started, after Hurricane Sandy. These contracts became very important for public safety, even though they're just trees, they're not major buildings, not mega projects. They're public safety contracts that are very important. What they said is, you don't really know where you're going to be from week to week. We give you certain community boards. You have to show up at that community board, so we can't anticipate what the utility impacts will be because there are no set plans. There is no site. So you couldn't really even go to the city. And what the contract required them to do, the city said, we don't want you to come to us. If you look at Article 15, it says the contractor shall cooperate with the city departments and utility companies, utility companies who own or control any services or appurtenances must be given sufficient notice.
No, I know, but what I'm saying to you is that if there's a dispute, doesn't the contract and common law both contemplate that you're going to go back to the municipality rather than just do the work and hope for the best?
Not when the municipality says, they've already anticipated it because they put it in the contract. You're going to see utility impact on this project more than likely. In that instance, you've got to cooperate with the utility. You have to notify them and work with them, and they're going to take the measures they deem necessary.
And you're saying that under the common law, if the utility and you disagree, then you get to make the decision?
Absolutely not.
Isn't that what you did here?
Not. Absolutely not. Let me be clear. If the utility says there's no impact here, that's it. There's no impact. If the utility says there's impact, but we're going to take care of it, so be it. If the utility says there's impact, we're going to bring somebody else in, so be it. If the utility says there's impact and you're going to do some work, but we don't like the prices or the amount of work that you did, that would be an issue that we'd have to deal with. That would be our burden to address. The issue here isn't what would happen in that case. It's the utility's call. If they took no action, zero action, and that is against the law. It is against the law, and it's dangerous, frankly, to say that the utility cannot even take a look at what's going on. Hey, there's an impact here. I need you to see this. We're not going to look at it. We don't really care. Just consider the fact that whenever you say there's impact, our answer is no. What was the point of having that provision in the contract? If I just could distinguish Ventolco, I don't know, because there was a question about Ventolco.
All right, we are way out of time.
Okay.
And I don't know if that's your paper or your paper.
Yes.
Okay.
That's all right. You got it.
Thank you, gentlemen. Schnur versus Balestri.
I knew it came out of someone's
jacket.
Yeah,
sometimes
no,
they can go
thank you.
crazy for it.
You may proceed.
Thank you. May it please the court, Seth D. Allen of Schwamstone and Dolan for the appellants Ifat V. Schnur and Ifat V. Schnur Esquire LLC. I'd like to speak specifically to two of the claims that the motion court dismissed that we believe were error. These are the defamation or slander claim against the Solan defendants and the Judiciary Law Section 487 claim against the Balashir defendants. Both claims were dismissed by the motion court, essentially because the motion court found that because the initial false allegations against the appellants were made in a pleading, there could be no claim. And we don't believe that there's any basis in the law for either of those
So
claims.
Section 487 requires deliberate misrepresentation.
Yes, Your Honor, and we believe it's clear that there was...
How do you say that you met that requirement?
Your Honor, we believe that not only did we meet that requirement, but that the fact that we met that requirement is actually res judicata here based on Judge Kogan's order in the federal action. Judge Kogan found, as a matter of law, that the claims against my client were not only without merit, but were frivolous and sanctionable and did sanction.
And he actually did issue a sanction.
He issued a sanction of $20,000 against the Balashir defendants. And before he issued that order in the transcript, which is in the record, he asked John Balashir, what facts would your clients testify to that would support the allegations against Ms. Schnur? And essentially, he could not come up with anything. And on that basis, Judge Kogan ruled not only to dismiss the claims, but to issue the sanction. And in fact, during that hearing, said that he would issue a sanction, but would hold off on determining the amount until the end of the case if he could see good behavior. And then during a later hearing, Judge Kogan decided that, in fact, what he said was that the defendants clearly have not learned their lesson because they continued to make false allegations against Ms. Schnur.
And also, the discovery in that action, didn't it establish that Schnur wasn't involved?
Yes, Your Honor. Both the depositions and the request to admit, and the responses to the request to admit, all of the pro se defendants in this action, who are the plaintiffs in the federal action, said essentially they had no idea who Ms. Schnur was, and they didn't know how she ended up as a defendant in the federal action. And then during their depositions, they testified essentially the same thing, with the exception of one defendant, Ms. Lytle, who had had some interaction regarding Ms. Schnur's request to speak to her attorney, Mr. Saland.
So, I mean, this is a motion to dismiss. This is a 30-11 motion. So, I mean, maybe you won't win or maybe you will win, but what you're saying is you ought to have at least a shot at this judiciary law claim based upon what happened in the federal proceeding.
Correct, Your Honor. We think taking the allegations, I say it is true, we believe that there's at least sufficient allegations here to sustain that claim.
Who is Schmidt and Grossman?
They are attorneys with the Balashir
Work for Ballasteri?
Yes. And we think the same thing is true as to the slander claim against the Saland defendants. And there's really no dispute as to what the law is. The law is that generally allegations in a pleading cannot be the subject of a claim for slander or defamation if they come from a pleading, but where what is called the sham exception applies, then they can be. And there's really no question that the sham exception is at least arguably applicable here, because what that requires is that the allegations against the defendant or the plaintiff in this action, Ms. Schnur, were false, and that the party who made them knew they were false when they put them in that complaint. And essentially what it says is you can't put something in a complaint and then rely upon the fact that it's in a complaint to say that you can't be subject to defamation when you go and spread those false allegations.
I mean, there has to be some basis for those allegations in the complaint.
There has to be some basis for those allegations in the complaint, and there has to be, frankly, some basis for continuing to spread them after those claims are made. And if we look at what the motion court said, the motion court essentially decided that the sham exception could arguably apply here. In fact, it didn't explicitly hold this, but the defamation claims against the Balashir defendants went forward because the motion court felt presumably that the sham exception applied, because those claims too are based on allegations initially made in a pleading. But what the motion court held with regard to the Salan defendants is that there was not sufficient allegations that they participated in the drafting of the complaint. And respectfully, to take Your Honor's point, this is a motion to dismiss. In paragraph 195 of the complaint, we allege that the Salan defendants helped to put together the federal action complaint. And there's absolutely no documentary evidence in the record that they did not participate in the drafting of the complaint. In fact, they don't really ever dispute that they were the co-counsel to the Ballester defendants. And we know this in a few ways. We know this because the allegations in the complaint about Ms. Schnurr, at least part of them, come directly from conversations that she had with Jeremy Saland. They're about conversations that the two of them have, which they then distort and falsify in the complaint. And so the Saland defendants clearly knew that the allegations about Ms. Schnurr that dealt with her conversations with Jeremy Saland were false. And knowing they were false, Jeremy Saland is in fact quoted in the first New York Post article about Ms. Schnurr that came out before the complaint was even publicly available. And finally, we know this, well, it's not in the record, we know this because in discovery we've received a handful, many documents showing that they referred to each other as co-counsel in speaking to reporters.
Okay, thank you. You have 4 minutes.
Good afternoon. May it please the court. I am William McCaffrey, attorney for the Ballester defendants in this action. And if I could begin by addressing the Judiciary Law 487 claim that was discussed earlier. The law is absolutely clear. The assertion of an unfounded allegation in a pleading, even if made for improper purposes, does not provide a basis for liability under Judiciary Law Section 487. There needs to be more than that, which is not the case here. In the cases cited in...
The allegation is that there's intentional deception.
Absolutely, but there has to be there has to be a basis for that deception, such as the case law that's cited in the briefs, that circumstances such as...
The complaint goes on to discuss the role of Schmidt and Grossman, and of course it's a matter of pleading and something which would have to be established, but there are all the allegations that emerged during depositions that they knew that Schnurr was not involved in this.
I understand what you're saying, but there has to...
Doesn't that rise to the level of intentional deception?
No, it does not rise to the level of intentional deception under the case law that's applicable in this matter.
Which is buttressed by the fact that there was a sanction imposed by federal court.
Correct, but the fact that there's a frivolous action or the fact that there's an action brought when there is uncertainty as to who potential defendants should be, in a simple case like a car accident case, a plaintiff may bring an action alleging that there's an owner and an operator, and maybe it turns out that they're not the owner and the operator.
But that's not the kind of case we have here.
But Your Honor, it is, because under the circumstances, they had a belief that that Ms. Schnurr was involved in this at the time.
But by the time this action was filed, there was no legitimate basis for that belief.
But we're talking the underlying action. At the time the underlying action was commenced, the underlying action being the federal court action. And the federal court action, at the time that action was commenced, there was a belief that she was involved. They were running up against the statute of limitations. It's no different than if...
Are we assessing that complaint or the one in state court?
The federal complaint, where she was named in the federal complaint as, for lack of a better word, a co-conspirator, that she was alleged in the sex trafficking case. That's the case that's at issue here. At that time, there was a belief on the part of the firm that she should be named as a defendant. The fact that it was later demonstrated that she shouldn't be named as a defendant, that she wasn't liable under the circumstances?
I mean, I hear that argument, but the federal judge found that it was frivolous of you to have made those allegations and sanctioned you for doing that, which that's kind of, that happened and that hasn't been appealed or that I'm aware of. So we have those findings already by a federal judge. So it's more than just...
Absolutely. And if I could address that. But there is a major distinction In the circumstances, as you're saying, well, it was found to be frivolous, the action was dismissed, and all of those things which are true.
Right.
In any case where there's a frivolous action brought and there's a dismissal and maybe sanctions are awarded or whatever the case may be, then what this court would be saying is that opens the door then to a Judiciary Law 487 claim.
No. What I think we're saying is that's a factor that we're looking at. Clearly, you were the only one who had the information as to whether those NDAs were, your clients knew, and in fact, they testified that those NDAs were signed years before this alleged sex trafficking. So if your clients have that information, you put something in a complaint that a lawyer is a control person in a RICO claim, and you have the absolute ability to find out whether that allegation is true or not, and you know it's not, obviously, because you spoke to your clients and you put it in anyway, that's enough on a motion to dismiss on a 487 claim to show actual knowledge of falsity of the allegation.
There are two issues, if I could just briefly address, Your Honor. Number one, that is why there is a heightened pleading requirement for specificity in a 487 claim that we do not have here. And the specific issues are, there is a major distinction between unfounded allegations in a pleading, which is the only thing alleged in this case, and the case law that does open the door to a Judiciary Law 487 claim, where there are things like
But that's not really right, because it's the allegation is that you knew that those allegations about the NDA were false. You knew that the allegations that she was a control person in the RICO claim were false, particularly because she wasn't even hired until after the period of the RICO claim and cause of action was allegedly, the RICO, the group was founded and started doing this. So that's the allegation. It may not be true at the end of the day, but this is a pre-answer motion to dismiss, right?
It is, but I would respectfully rest on the cases cited in my brief, where there is an absolute distinction between the cases that allow for an action to proceed under these circumstances and cases where it's the case, as is here, that it's simply based upon the unfounded allegations, that is frivolous and things of that nature. And I know I'm out of time, so I'll rest on my brief.
Thank you.
Thank you, Your Honors.
You may proceed.
Good afternoon, Your Honors. Rachel Agassi of Furman, Kornfeld, and Brennan for respondents Jeremy Salon and Salon Crody. Plaintiff here seeks seemingly to undo the fair report privilege, which was codified under New York Civil Rights Law 74, which allows attorneys or really anyone to give a fair report to publications of ongoing judicial proceedings. That has been explicitly extended to attorneys. And to find otherwise in this case would really open the door for every time a legal proceeding fails to assert this type of defamatory claim against an attorney. And here, even more so, the statements by Mr. Soland pertaining to Ms. Schnur actually had very explicit relation to the allegations that continued against Ms. Powers and successfully against Mr. Rubin, which a plaintiff's verdict resulted in almost a $4 million judgment for sex trafficking. All of the allegations in the complaint that he relayed to the New York Post actually continued in the operative complaints long after Ms. Schnur was dismissed from the case in four amendments of the complaints. And I would say in our motion papers, we said even now they're the operative allegations, but no longer because there has been a plaintiff's verdict in that case in some sense based on those allegations. Plaintiff tries to assert a very limited circumstance of a so-called sham action here to undo the very clear language of the fair report privilege. That only applies in limited circumstances where the allegations were specifically to cover the defamation, and in the cases that plaintiffs cited where courts found sham action or the possibility of sham actions, those were when the plaintiff was a competitor and was distributing complaints to other competitors in order to
gets some kind of financial benefit. That's obviously not the case here.
Can
Or-
you address the issue of whether Saland was co-counsel?
Right, it's my understanding that he wasn't, but we haven't really addressed that with him because the allegations really
And if that is the case, does that change the outlook here?
Absolutely not, because his statements don't relate to the NDAs. His statements only relate to what he understood to be Ms. Schnorr's efforts to contact his client in the criminal action, Ms. Lytle, and be retained as her counsel there. And his client, and she even testified to that, Ms. Lytle testified to being offered $80,000 by Mr. Rubin in order to change attorney to Ms. Schnorr. So that was his understanding, and that is exemplified by his texts and emails and phone calls to Ms. Schnorr, which Ms. Schnorr does not contest occurred, where he states, please do not contact my client. So his statements to the New York Post, which only relate to his perceived view of Ms. Schnorr's efforts to be counsel in the criminal action, that still applies here and really doesn't relate to the NDA and doesn't relate to the RICO allegations against Ms. Schnorr.
Thank you.
Thank you, Your Honors.
Thank you. Okay, you have 2 minutes.
Thank you, Your Honors. Just briefly, responding to both counsel, I think it's important to understand what the allegations were here. The claims against Ms. Schnorr, she was sued as an attorney representing a client, claiming that she was a member of a RICO conspiracy engaged in sex trafficking of women. And so I think the fact that the defendants could be so haphazard about including her in a complaint, and in fact, in continuing to include allegations against her, as counsel just said, Ms. Schnorr, allegations about Ms. Schnorr continued to be included in the federal action even after they were sanctioned for including the claims against her. They continued to include these false allegations against her in the RICO statement, in the amended RICO statement, and in the second, third, and fourth amended complaints in that action.
It's more not just the assertion of these, what turned out to be unfounded allegations, but it was the continuing on after the case had proceeded to a point where the federal judge found it frivolous and sanctioned them, and still continuing.
Correct,
So
Your Honor.
that part of it that you're really focusing on, I guess.
Correct, Your Honor. I mean, we do believe that under Amalfitino and the other cases that the intentional misrepresentation, even if it was only in the initial pleading once, is sufficient to state a claim under 487. But that, in fact, is not what happened here. It is repeatedly asserted against Ms. Schnorr. In fact, it continues to be asserted against Ms. Schnorr in this action, in the abusive process action that the Balistrieri defendants filed against Ms. Schnorr for having brought this action, in which they continue to claim that there was some basis for the allegations against Ms. Schnorr. And Ms. Schnorr continues to be harmed by this conduct on an ongoing basis. I mean, even recently in the last 2 weeks, opposing counsel in another case where she's merely an attorney has contacted the court saying, you shouldn't trust this lawyer because look at these horrible claims about her. And that continues. And even in the briefing here, the defendants continue to claim that they had some basis when they were already sanctioned for bringing these claims against Ms. Schnorr. And that's why she's continuing to bring this action, because until there's a finding and a decision that these defendants must stop claiming false allegations against Ms. Schnorr, she's going to continue to be harmed every day.
Thank you so much.
Thank you.
Hoffman versus Tobel. You may proceed.
Good afternoon, Your Honors. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch on behalf of the defendants' appellants. This appeal asks a simple question: whether or not a plaintiff can successfully defeat a summary judgment motion by submitting an opposing expert affirmation, which really says nothing more than, I disagree,
Or
Let me-
before, go ahead.
Well, I was going to ask you, before we get to the plaintiff's opposing expert affidavit, isn't part of the claim, I mean, part of the issue here is your expert affidavit, and did you make out enough? I mean, you said in your, I mean, not you, but your expert said, well, this would not normally be what caused these situations, and this might, you know, and it might be some, what do you say, it's my opinion that the current urinary issues relayed by the plaintiff are unrelated to this, and they're commonly done like this. Did you put in enough, did your expert put in enough to even worry about what the plaintiff's expert said?
My answer is obviously yes.
Well, obviously, but explain to me why, because I read
If you look at page 56 of the record, he said, he doesn't just say there's no causation. He says it's a result of, these are common signs of stress incontinence that's secondary to pregnancy. He says the plaintiff has a longstanding history of depression and taking medications for that disease, and that these things.
You don't really tackle the fact that there may have been departures, but your claim
No,
is that...
I've tried to make very clear that we are conceding for the purpose of this appeal only
Right.
that this is a causation argument on appeal.
Well, I didn't want to go so far as to say you concede departures, but basically...
No, for arguendo.
Right. But you're saying there's no causation. I mean, and do you establish that lack of causation once you basically concede the departures?
I think the answer to that is no. Not every case in which there's the departure necessarily means there's causation. That's why there's separate elements. You need departure, causation, and damage in any medical malpractice case. They're all three separate components.
Because you need a detailed presentation of why there's no causation, and you can't rely on the reply affirmation because you've got to make your case on the initial.
Okay, so let me address the reply. Well, let me address the initial presentation that we did and the reply. I just read from the initial, okay? And the plaintiff doesn't say anything about any of those initial things other than that I disagree. I don't even know what that disagreement means.
But still, what you present has to establish a prima facie case, and I am struggling to find one.
Your Honors, if you don't think this made out a prima facie case, then you're right. I think this makes out a prima facie case. It points to alternate causes and explains why those causes would result in her current problems.
Counsel, did your doctor submit any diagnostic testing that would show that those symptoms were caused by the other issues that he raised?
No, and that's interesting because that raises what my doctor did eventually say in reply.
No, we're not looking at reply. You have a prima facie, right? Let's start
No,
with
he did not. He went on the patient's
So there's
history.
nothing, there's no
Patient's history and
diagnostic
presentation.
testing. Right. There's no diagnostic
He
testing.
did not point to any specific diagnostic
Are
test.
there any medical records that he pointed to that would say that would support his conclusion that this was from something else and not the departure?
He cited to her general history. I don't think he cited to a specific page in any medical
Okay,
record.
so no
but there's-
medical
but there's
records,
no
no diagnostic testing to support his opinion that all of her issues were from something else.
Okay, but there's,
And you're
again,
saying that that made out his prima facie case?
I am saying that there is no dispute that she had all of these problems, okay? And interestingly, the plaintiff's expert, while saying broadly, I disagree, also doesn't dispute that that she suffers from everything that my expert relied on, okay? But all he does is say, I disagree. He doesn't explain why the medication she was taking, which he concedes, or she concedes, were being taken, couldn't result in this. Okay? The expert doesn't say that, oh, if I'm taking these medications, that's no explanation for her long-term problems. He doesn't say that, oh, well, I know because of this, dosage of these medications, there was no link. Okay? He just doesn't say anything. Okay? That's where I have the problem. And in terms of, I think it was Justice Friedman who started asking me about the reply. Obviously, the general rule is that you can't put anything in reply for the first time, okay? But this is different. Here, the plaintiff themselves proffered diagnostic testing in opposition to our motion. And all my expert did was comment on the plaintiff's proffer of evidence, which proved our case.
Except that you had to do that in the first instance.
Again, I think what we did in the first instance was sufficient, okay? What they did was just bolster our case for us.
All right.
Thank you.
You may proceed.
Good afternoon, Your Honors. Arnold DeJoseph for the plaintiff respondent. I hope everyone had a nice summer. I think the court understands the issue in this case. I think what the defendant is asking you is to just ignore the fact of what they submitted in their original motion practice, and they even did the same thing on appeal. In their reply, they finally address all the issues. They had to do that, and the court's already said it, in the initial paperwork. Then the plaintiff's experts would have been able to respond to it. When you do it in a reply, Justice Friedman, you cannot respond to it after. That's why it's improper. So what they did in the court below was totally improper. The court recognized it and just granted summary judgment, and this battle that they believe exists will ensue another day. Thank you.
Thank you.
Okay, just very, very briefly. In terms of the reply, this wasn't something we came up with late. This is something they proffered as evidence and we commented on. How come their expert, who can't say anything more than we disagree, didn't look at this diagnostic testing, which is their evidence, and comment on it? Okay, we already, I know you may disagree, but we already believe we made out our prima facie case. If they're going to introduce evidence, why don't they themselves comment on it? And why do they criticize us for having the nerve to comment on it? Thank you.
Thank you. People versus Tony Santiago. Is that submitted? Sorry. Papas versus B&G. You may proceed, sir.
Good afternoon, Your Honor. Alan Ahern for plaintiffs' appellants, the estate of William Egan and Dean George Pappas. Your Honors, this is a construction proceeding of a partnership agreement between two partners, one of which is now deceased, and also that deceased partner's will. Initially, there's two provisions in the partnership agreement that are at issue. At record 63, Your Honors, there's the prohibitions against lifetime transfers. In that language, Your Honors, the lower court incorrectly found that that language also prohibited testamentary bequests. Your Honors, nowhere in the partnership agreement are there any prohibitions against testamentary bequests. The Court of Appeals has said...
But can a testamentary bequest undo the terms of a contract that have been entered into between two parties?
I wouldn't think of it as undoing, Your Honor. It's just that the contract...
Well, if the contract says one thing and the bequest flies in the face of those terms, isn't that doing an end run around the contract?
No, Your Honor. The contract itself still has to be adhered to, and the Court of Appeals has said that a testamentary bequest, in order for that to be renounced by contract, it must satisfy the statute of frauds, and it must be clear, unequivocal, and it must be expressly stated, leaving no doubt. Cited in my brief, Your Honor, is American Committee versus Dunn. Page 92 of that case, there's some strong language that says, leaving no doubt. It must be an unequivocal statement in the contract that to renounce a testamentary bequest, the party to be charged is doing that in the agreement in a knowing fashion, affirmatively. It's not the kind of thing where we can look into this transfer, these prohibitions against lifetime transfers, and glean from that there's also an affirmative renunciation of the right to make a testamentary bequest.
Well, but you point to page 63, so let's look at 2A on page 63. No shareholder shall sell, transfer, pledge, hypothecate, negotiate, assign mortgage, or otherwise dispose of. What does otherwise dispose of mean?
Well, Your Honor, all of those words and all of that language, the way I read that, is that during the lifetime, and first of all, it's under the heading lifetime transfers, all of that language would require that during the lifetime, the partner would have to do some sort of transaction, take some action
that is going to divest that partner of their interests, or at a minimum,
Well,
create
when
a
he
lien.
leaves that interest to Mr. Pappas, he's doing it during his lifetime.
Absolutely not, Your Honor, because a will is ambulatory.
It happens afterwards, but when he does it, he's disposing of it during his lifetime.
Your Honor, respectfully, I disagree, because on the law, a will is ambulatory. It can be revoked at any time, and by its very nature,
Otherwise dispose of seems to be such a broad phraseology looking to cover any and all possible dispositions of the property.
it might be broad, Your Honor, but it does not meet the standard and the requirement that is very clearly stated in American Committee versus Dunn, which says that it can leave no doubt, not some sort of broad maybe. It has to leave absolutely no doubt, be clear and unequivocal.
Okay, got it. Let's say the bequest is legal. Now what?
Your Honor, then we look at Record 67, the next language that would be important in this partnership agreement. It says that upon the death of a partner, that death is deemed an offer by the representative of the estate to transfer, or to sell to the surviving partner only those assets that are held by the estate. Possession, Your Honor, held by the estate. As a matter of law, we now must go look at the will. Since if we're finding that the bequest language is not included in the partnership agreement, and if the language says, and if you look at it clearly, all interests that are held.
When you look at page 67 at 4A, the death of a shareholder or partner shall constitute an offer of the personal representative of such deceased shareholders. I mean, this takes over and says that upon death, that's an offer. You may have given it away by a specific bequest, but that's not consistent with what the partnership agreement says, neither in 2A nor in 4A.
Your Honor, respectfully, I disagree, because if you read that very carefully, it says that only those assets or interests or stocks that the estate has in its possession, that which it is holding. And as a matter of law, and you know, the will, when you look at the will, because of a specific bequest, and there's a lot of case law, I have additional citations that I'll be filing later today, a specific bequest transfers title immediately. Under the tax code and under the EPTL, you don't see that language specifically, but what you do see is that a fiduciary has absolutely no authority to take possession of assets that are specifically bequested. They transfer immediately upon death. That's whether it's real property or personal property. That title transfers immediately.
Under the partnership law, the death of a partner, leaving only one partner behind, dissolves the partnership.
And then you default to the partnership law, which would require under sections 68 for a windup and under 74, the partnership law, that the surviving partner must then account to the personal representative of the estate. But if you look at the Nassau County Surrogates Court case of Grace from 1970, which is where this matter is being probated, Your Honor, that case very specifically says that the fiduciary is only in a position to handle the accounting purposes, but not to take possession. And the reason being is that would be the logical person to whom the surviving partner would have to account.
But under Gross versus Nyman, you don't have a right to be involved. Pappas doesn't have a right to be involved in winding up the partnership.
We're not asking to be involved in winding up the partnership.
Well, what's your first cause of action for?
That's because, Your Honor, under partnership law provision 68, that provision allows for, upon good cause shown, for anybody, in particular a personal representative of the estate, to seek a winding up. And this is only two partners and one is now dead. And Mr. Pappas, as a specific devisee, is the only one who actually has possession of the assets, and so a winding up in accounting has to happen, but that's incidental to what I think this court should find.
Isn't that a separate thing? I mean, winding up is one thing and accounting is another thing.
They are separate, Your Honor.
So I mean, I still don't understand why there's still why there has to be a winding up based upon the law we just mentioned. The accounting could be something, is a different issue.
Understood. And even if there was no winding up and for some reason the surviving partner was able to continue with the partnership or in business, he would still have to account for the value of those interests. And so even if the court said no winding up, but there must be an accounting, and just if I may on that point.
You can do that on rebuttal because you've gone way over time.
Thank you, Your Honor.
may proceed.
Good afternoon, Your Honors. Jack Piana for the respondents, B&G Holdings and Eugene Leo Grant. Your Honors,
Counsel, can I just ask, sort of to go from what we just ended with, why would he not be, Mr. Pappas, not be entitled at least to an accounting in this case?
two reasons, Your Honor. The first reason is that the partners of B&G specifically accounted for. They set out the exact methodology through which the partnership interest of a deceased partner would be valued. At that time, at Mr. Egan's death, the attorney for Mr. Leogrand set forth the exact calculation as set forth in the partnership agreement and told him exactly how it was going to be valued, and in his election to purchase that partnership interest, set forth the methodology and the exact amount that would be due to the estate of Mr. Egan.
Doesn't partnership law section 74 provide for an accounting upon dissolution as a matter of right and law?
So, Your Honor, I would say that the right to an accounting is specific to the partnership interest held by the estate of the deceased partner. What Mr. Pappas
What does that mean?
It means that the partnership interest that is held by the estate of Mr. Egan is specific or segregated at this point to the remainder of the partnership. Mr. Pappas is seeking an accounting of the entirety of the partnership. He's only—
Oh, wait, no. The partnership was held 50% each side, correct?
Yes.
So why would whoever the estate is, be it Pappas or anyone else, why would they be required to accept your figure on what the value of the partnership is without seeing an accounting in order to verify whether the numbers that you have reached are accurate?
I don't, and Your Honor, I don't think that is the issue that's being raised.
It doesn't matter whether that's the issue. That's the issue I'm presenting to you. So if, under this agreement, the remaining partner had the right to consider the death of his partner as an offer of those interests, correct?
Yes, Your Honor.
And so there was a method in the contract on how to reach that valuation.
Yes, Your Honor.
I would imagine that that included assessing the assets of the partnership, right? It would have to be.
In some manner, yes, Your Honor. It was
Okay, so how else would someone with interest, remaining interest, know whether you have assessed that properly without an accounting? You're asking them to blindly trust your number and go away.
If that was the—
That's just never going to happen, and you know it.
Your
right?
Honor, well, if that were the issue that was ever presented to Mr. Leogrand, then that would certainly have been a discussion, but that wasn't the issue. It was the methodology itself. It was the language of the partnership agreement that was called into question.
What in the partnership agreement specifically eliminates the holding of an accounting?
I'm sorry, Your Honor, I didn't—
What language in the partnership agreement says they're not entitled to an accounting now pursuant to partnership law section 74?
It doesn't specifically say that they're not entitled to an accounting. And my position is that the accounting, if there is to be an accounting, it is confined specifically to the partnership interest that was held. And what—
If there's an accounting, it's going to be as to the whole partnership.
But there's a specific methodology. I guess it's not liquidation value. It's not— the partners agreed to a specific way to assess the value of the deceased partner.
It sounds like what you're saying is that Mr. Leogrand made an offer which he did not accept, a $380-something thousand. He didn't accept it. He said, I want an accounting. Now, under partnership law 74, section 74, it seems to me, maybe I'm wrong, that he is entitled to an accounting. How the heck does Mr. Pappas know about the evaluation? You can argue about the methodology, but he is certainly entitled to an accounting. of the value of the partnership. What else are we talking about? The value of the partnership. He gets half, you get half.
We're talking about the value of his partnership interest.
Yeah, okay,
Right.
so.
Which
he
is
gets-
different, I'm sorry, Your Honor.
It's different.
Counsel, it's 50% of the whole. So you're saying, no, this is your 50, this is my 50, and my 50 could be worth 500,000, but yours is worth 318,000. He has the right to make sure that both halves are equal, because they're 50-50 interest.
Respectfully, Your Honor, the partnership agreement calls for the partners to, at the end, at the election, when they make the offer, it's 12 months of the rent rolls of the properties multiplied by 8, and then when you get to that, you have to reduce the amount by the outstanding mortgages, and then it came to about roughly $637,000.
So it sounds to me like a lot of paperwork you need to turn over so that they can assess whether your valuation is correct.
They never
I
asked for
need
it.
copies of the rent rolls for 12 months. I need copies of the mortgages to see what's still outstanding, et cetera, et cetera, et
Well,
cetera.
I mean, the first cause of action, wait, the
The
second cause
second.
of action is for an accounting. What do you mean they never asked for it?
Well, no, they didn't ask for it initially. They've
what?
demanded,
But under
they've
this-
demanded for an accounting, and they have demanded an accounting for the entirety of the partnership, not using not an accounting of the methodology that the partners agreed to in
It
this
sounds
partnership
like you're saying that it's a specific methodology that's supposed to be used in doing the accounting. This is a pleading motion. Isn't that something to be sorted out in the course of processing the second cause of action?
I'm sorry, I'm not.
The second cause of action is to have an accounting. You say there's a specific way to do the accounting. If the cause of action for accounting is not dismissed, that's something that you're going to have to thresh out in the course of processing that second cause of action.
I would say two things to that. Number one, and was cited in the brief, there are two cases that cite in the First Department, Raymond v. Brimberg, that when a specific methodology is set forth in a partnership agreement, that there is a waiver of the partnership of the individual partners and their beneficiaries to a formal accounting, because it is very clear exactly how the partnership asset, the partnership interest should
So
be done.
he just has to trust you lock, stock, and barrel and have
Apparently.
no opportunity to review it. Is that what you're saying?
And again, if the issue was, can I see the rent rolls, or can I see the
Can I see all the records that your valuation is based on?
that was never the question.
But that's what they would be entitled to at a minimum. At a minimum.
Your Honor, that would never be, wouldn't be the issue. The issue is that they're saying we want an evaluation of the entirety. They're asking to partition and sell.
That's a different
That's a
cause
different
of
issue.
action.
Absolutely, but that's what they asked for in the accounting. The accounting cause of action asked for an accounting of the entire partnership, which they're not entitled to. Citing Raymond v. Brimberg and Hand v. Kenyon and Kenyon. I know that I'm out of time, but the plaintiff appellant cites cases that are just not on point to any of these discussions. They're changing their relief that they're requesting at the appellate level, and citing lower court cases that were reversed in support of it. I respectfully ask that Your Honors affirm Justice Shannon's decision.
Thank you.
Thank you.
Counsel, you have 2 minutes.
Thank you, Your Honor. Your Honor, respondents at one point did say that they provided an accounting, and as the court, I think, has picked up, all they gave us was a correspondence that told us a number. So I do think that that is something that's sorely lacking.
Wait a second, are you saying, on your second cause of action, are you saying I dispute the methodology of the accounting?
I think
that's
that
in the-
methodology only applies, Your Honor, if we were agreeing that it even applied at all. I don't think it does, simply because the partnership agreement, we're dealing with testamentary bequests.
Okay, but in your second cause of action, all you say is, give me an accounting. That's something, and this is a pre-answer motion to dismiss, correct?
Pre-answer motion is dismissed, correct? We have
So,
no
and there's a partnership law that says you get an accounting.
Yeah,
The methodology is something down the road. And we might agree or disagree with your assertion that the methodology that the partners agreed to doesn't apply, but we don't have to deal with that now. Okay.
Your Honors, there's an important issue that's been created, I believe. And if you
The
read-
Section 74 grant of a right of an accounting is not unequivocal. It does also say unless there's an agreement to the contrary. And I think what your adversary was saying is that we do have an agreement to the contrary because this is not subject to your typical accounting. The agreement sets forth how the valuation is to be made, and any valuation that's to take place has to be consistent with that agreement.
That only applies if it is either a lifetime transfer, those valuation triggers are then triggered, or those methodologies are triggered, or
But again, you see, so my very first question to you, you are basically answering it now. Having received this interest through the will, that just wipes out the entire contract as far as Mr. Pappas is concerned. Those terms of their partnership don't apply to him. That's what you're arguing.
As a matter of law, they don't, Your Honor, because that language is a lifetime transfer, and a will transfer is
I don't
nothing
know
until
that you're
after death.
correct about that,
So
but
if we don't,
That's
we don't agree with that, what does that do to the accounting cause of action?
The accounting still has to happen under Partnership 74 regardless.
Or pursuant to the terms of the agreement?
No, because the agreement in this case doesn't apply.
But if we don't agree with that?
Well, Your Honor, if you don't agree with that, Mr. Pappas is also then left with taking his accounting from the estate to the Nassau County Surrogates Court and stating to the Nassau County Surrogates Court that he is in possession of, as a fiduciary, of these partnership assets and interests, and by law, he is not, and he cannot submit that accounting. That creates a conflict between this case in the Bronx and the Surrogates Court, because if you read the will, he possesses
But
none.
that's not an issue we have to decide here, and I thank you. Have a good
Thank you, Your Honor.
Okay. All right. The last case being argued, First New York versus New York State Division of Housing. Judge Kapnick is recused from this case, and the standard rules of the appellate division apply. If there is a tie, we will vouch in a fifth judge. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the Court, Jason Sorolnik on behalf of Appellant, First New York. Your Honors, New York State's applicable rent stabilization statute and regulation make clear that whereas here, a property owner intends in good faith to demolish its building, it is permitted to do so and it may decline to renew a tenant's lease. The reason for this rule, Your Honors, is straightforward. Rent-stabilized tenants do have many rights to keep their stabilized units, but not at the expense of forcing property owners to sacrifice their own rights to demolish their buildings, their dilapidated buildings, when they see that to be fit. In other words, the tenant's rights, Your Honor, do not trump the property owner's rights to demolish their building. They do trump certain property owner rights. If a property owner, Your Honor, wanted to replace the tenant with a more profitable tenant, that is exactly what this statute is designed to preclude.
It also says you can't say you're going to demolish unless you really can show that you're going to demolish.
That's exactly right, Your Honor. The reason why the statute
But
and
it
the
doesn't
code,
say anything about having to show that what building you're about to put up.
Your Honor, you're exactly right, and it's not just that. If it were only that, it would be clear, but it's actually worse than that. 22 years ago, Your Honor, the language that you just said is missing was actually in the code. That language for post-demolition construction plans and post-demolition construction ability was in the code. It was deleted. It was crossed out by DHCR, gone. And in the ensuing decisions that DHCR has issued on this very subject, DHCR has said to petitioning tenants, sorry, the code has changed. You no longer get to tell us that we have to look to post-demolition plans, financial ability. That's no longer part of this rule. And so, Your Honor, with the governing statute at issue here, it is both crystal clear that the only thing that a property owner needs to show is that it intends to demolish and that it has the funds not just to do so, but segregated. And pages 191 and 192 of this record have that clear. There's not a person in this courtroom, I think that would have been more powerful if I had been first, but there's not a person in this courtroom that would disagree with the proposition that the appellant here absolutely intends to demolish. There are 9 lots that have been either entirely demolished, 9 buildings demolished, or in the process of being demolished. I think 2 of them are in the process. One remains. It's this one. They are trying to get this property set up for a real project, a project that will benefit hundreds of families and schools. And what the DHCR here did is they said, we want to know more about your post-demolition plans. And the statute says you're not allowed to do that. You are required.
Has DHCR issued any decisions related to this issue where, notwithstanding the lack of language in the statute, where they still have reached the decision that you have to show us what you're going to do? And is the answer to that question yes?
I believe there is one decision which is on appeal, which went to the Supreme Court and is on appeal before Your Honors next month, I think.
Okay.
That's the 118 Duane decision from Justice James that she reviewed. So I think the answer is yes, they issued one that I'm aware of.
Okay.
And they did not address the change to the amendment. The decision that does address it specifically was the Brady decision, where they said you are not allowed to rely on post-demolition demonstrations or financial ability to stop a property owner from exercising its rights.
Okay.
So, Your Honor, in terms of translating that to the Article 78, and we think the result here respectfully should be clear, not only does the statute not permit this, the statute explicitly says that you must allow a property owner to exercise its rights here. Look, there are millions of reasons why a property owner would want to demolish a building. They don't necessarily have to have their entire plan finished. They don't have to have hundreds of millions of dollars segregated in an account for a future construction project without even knowing what that's going to be. That's exactly what the legislature decided. But they do have to have the $448,000 that is necessary to complete demo, and they need to have a permit to do that. Here, Your Honors, they had both. They had $1 million in a segregated account in Bank of America, pages 191, 192 of the record, that says segregated account for purposes of demolition. There is no dispute that they met the statutory requirements, and it is time to stop this holdover tenant, the one tenant on this block that remains in any of these buildings trying to extort Extel from First New York from being able to finalize this project on the basis of a faulty reading of a statute that has been amended 22 years ago. And Your Honors, without any further questions, I'll rest and save for my 60 seconds of rebuttal.
Thank you. Okay, you got an extra minute then.
Thank you, Your Honor.
All right.
Sandra Joseph for the respondent, DHCR. The court below found that there was a rational basis for DHCR.
How do you deal with the fact that there's a change in the governing regulation?
Well, the regulation states undertaking. It doesn't state...
Well, the word undertaking, as you read that regulation, clearly refers to the demolition. If you're to read that undertaking as referring to post-demolition work, it really sort of does violence to the construction of that sentence. It's clear that undertaking is referring to demolition.
Well, it may be referring, but if they wanted it to just be the demolition to show the money for the demolition, then they would have said demolition, but instead...
But counsel, isn't that exactly why they changed the statute? I mean, how do you ignore that? I mean,
I'm saying the statute doesn't say demolition. The statute says undertaking, which is different than a demolition. A demolition is just knocking down the building. An undertaking...
So then what effect do you give of the removal of that requirement of showing...
You don't have to build a new building. Let's say hypothetically, this is just hypothetically, that they were going to knock down the building and put in a parking lot, or put in a tennis court, or put in a swimming pool. They would just have to show that they have the financial resources documented.
Don't they also need to show that they have agency approval for the demolition?
Well, it's not.
And isn't that part of what that regulation requires?
It's for the undertaking. It's not for the demolition. Also,
it's not just money. It's not just money. The regulation reads, and plans for the undertaking have been approved by the appropriate city agency. You've got to have the city agency approving your demolition.
Approve the demolition, and if they're going to put in a swimming pool. And you had asked about Brady. Brady is a decision that DHCR issued that actually approved an undertaking where the tenants opposed it because the owner showed what they were going to do with the property afterwards and showed the financial resources in order to do it. DHCR approved that application to not renew leases.
So what if the owner doesn't know what they're going to do with the property afterwards? Does that mean they automatically
Well,
get
the problem
denied?
with that is that if you just have a demolition, and the owner can say, well, I'm going to take down the building and evict a tenant, and then decide not to demolish the building, then what recourse is there for that tenant that he's been evicted and because the owner changed his mind?
You're pointing to lots of hypotheticals which really don't seem to have anything to do with the situation that this case involves. I mean, no one thinks that they're putting up a swimming pool on this property or they're putting up a parking garage. I don't know, there might be a set of facts where the issues that you're raising would have application, but it doesn't apply to what we're talking about here.
I'm sorry, Your Honor?
It doesn't apply to the factual background of this case. I mean, this is one lot of many lots and the others have been taken down. And you say, well, maybe they want to put up a swimming pool. I mean, it's...
I honestly don't know, but it involves...
Manhattan real estate is too expensive to put a swimming pool in,
Yeah,
okay?
it involves a
So,
tenancy.
that's not gonna happen. I mean, come on. There's, as my colleague said, there's a bunch of lots adjacent to this, some that are already ready. It sounds like there's a big project coming down the pike and they're not ready to say what that is yet. And the question is, do they have a legal obligation to do so in order to move forward is the issue.
And according to the rent stabilization law and code, until they provide the documentation and their plans, approved plans for the
That's not what the
city.
statute says. It doesn't require post-demolition information.
It says for an
That's not what the statute
undertaking.
says. Next, 3 minutes.
Good evening, Your Honors. My name is Peter Kerwin, and we represent the rent-stabilized tenant, Mr. Marshall. I wanted to pick up from the question that were presented with the actual law, which says you have to show good faith. In this instance, the landlord didn't show good faith because they were in a prior 2015 demolition application. They disclosed fully their $95 million assemblage. Here, however, they were asked to say, what's your project or your post-demolition undertaking, and they refused. So to
But
me, that's
so
bad
what?
faith.
If the statute doesn't require that they do it as a part of this application, so what?
Because the law, the rent stabilization law says you must do so in good faith. The Court of Appeals has already held, I think it's the matter of ASCO, that good faith means you have to do what you say you're going to do. Here in 2015...
Well, here what
and
he
they've already
says, what he says he's going to do is demolish the building. That's the only issue before this court.
That would mean then that all the landlords would file demolition applications if that was the standard, leave the property unused for years and years and years until they can flip it to somebody else. That's why the law says good faith, and DHCR has interpreted that good faith to mean
The law uses the specific words good faith in the statute?
Yes.
Where is that?
The rent stabilization law.
I'm looking at 2524.5821.
That's the code, the rent stabilization law.
2.1 doesn't use the words good faith.
That's the code, it's the rent stabilization law.
But wait, but you're saying that the owner of the property is not allowed to tear down a bad building and wait a couple of years in a bad environment to get a better price? That's not allowed? That's automatically bad faith?
It's bad faith when the administrative agency asks you what is the purpose of the demolition, and the landlord says, I don't have to tell you that. And we already know what they plan to do, because in 2015 they submitted the application, which was denied by DHCR because they didn't have, XL Corporation didn't have $95 million or wasn't able to prove that it had $95 million. So the owners came up with this clever idea that we're just going to submit a second application as opposed to appealing the first or filing a par, and we're going to just take away and not disclose the undertaking.
But isn't that what the statute says, that they don't have to tell you what they're going to do with the property after it's demolished?
the rent stabilization code says that you have to disclose the undertaking, and the rent stabilization code operational bulletin actually uses the word undertaking and project to make it clear that in order for the application to be granted, you have to disclose we'll call it undertaking. I think what DHCR was saying is that undertaking, this change in the code, not the law.
Well, you're right that Section 26-511C9A does use the word good faith, but it uses in term good faith to demolish.
Correct. But in order for them to determine good faith, you need to know what it is that they're planning to do.
So it goes back to my colleague's question. So you are saying that a property owner cannot do what they want to do with their building unless they know what's coming next. And when we are talking about multiple lots, the layers of financing involved in that kind of project don't happen overnight. And they usually require multiple partners and multiple contracts, etc. So this is not something that necessarily is doable prior to demolition.
The owner makes that argument in their brief, but in the reality, in 2015, they submitted the full plans for the project, for the full assemblage, and they weren't able to show that they had the money.
And obviously, they didn't have all their financing in place, so they couldn't support it.
So what they should have done is perhaps file a new application and disclose the undertaking, as opposed to arguing that they don't have to show what their plans are. And it doesn't necessarily have to be a new building, because that was taken out of the rent stabilization code. Thank you, Your Honor.
Thank you. You have 1 minute.
Thank you, Your Honor. I did get an extra 60 seconds, but I'm keeping
that's right.
But
Go ahead.
I'm keeping it to 1 minute.
All right.
Candidly, Your Honor said it better than I could have, and I have to admit that with my client listening. So the bottom line here is that if Your Honor's question was posed 22 years ago or 23 years ago, the answer would have been yes. Do they also have to tell you what they're going to do afterward? The answer would have been yes. And I would have been out of this courtroom, and it would have been an affirmance. But that was changed. You literally have the legislature dealing with that very issue, and it's gone. I want to address this undertaking point just because it's misguided. But before I do that, I just want to address the sort of thematic point that I heard from my friends on the other side. Your Honors, there's currently an amendment that is under consideration to add another requirement to this regulation. And the amendment is, if the owner doesn't complete its demolition within a certain reasonable period of time, then there are certain penalties. And the answer to my colleague's question is, that's how you deal with this. Make your pleas to the legislature, add in a requirement like that, and you don't have to worry about some untoward property owner pretending to want to demolish to really put in a new tenant. Nobody in this courtroom thinks that's what's going on. We have the preeminent developer in the city who wants to create a great project. You have 8 out of 9 lots gone. They're trying to demolish a dilapidated building, and if that regulation passes, that amendment passes, then that's the way they deal with that. The last issue on the undertaking, just so I can read it into the record, the language of such undertaking is so clear. It's true it uses the word undertaking, but only after the word demolish. The language is the owner seeks to demolish the building, period, until the owner has submitted proof of its financial ability to complete such undertaking. And that's the word.
It clearly refers back to demolition. Absolutely. It clearly refers back to demolition.
Refers back to demolition. There's only one antecedent that's possible, such undertaking, and that's the word they left out of their presentation. It's not some ambiguous term. What does undertaking mean? It literally says you have to show that you're going to demolish, and you also have to show the financial ability for such undertaking. Is there any question as to what that means? Your Honors, with that, I rest, and I thank you very much.